ಏನ್ರಿ ಸರ ಇದು
It's not audible, I think.
Page of judgments. Page number 7, till number 27. Page number 8, 28 to 30.
My lord, page number 8 in serial number 28, my lord. I am for respondent in this case in senior counsel in engage. I have it on 28, my lord. 2810, my lord.
We can't give dates like that. We don't know. I'll adjourn it.
But my lord, senior and yet
That you move it one day before and you get your date fixed.
on
It is the matter after Dasara vacation.
Page number 9, till number 35.
My lord, serial number 34.
30,
34.
34.
Yes,
CL for respond to the party after occasion.
this is the matter after Dasara vacation. Inform the other side.
Informer.
Page number 9, till number 35. Page number
My lords, my lords,
Yes,
serial number 37 and 39, my lord.
page
just
number
wait, just wait.
36 to 39.
my lord.
Serial number 37 and 39, my lord.
37 and
39, my lord. In 39, I already informed to the Sachin Mahajan, sir.
39, my lord. 39, my lord.
37.
37.
37, let us see. When it reaches, I'll see. 39.
So 37 out of station in Swami 37 and 39 opening day, kindly it may be taken on 15th, my lord.
My lord, I am contesting respondent number 6 in serial number 39, my lord.
39 list.
39 ಅಲ್ಲಿ report ಬಂದಿದೆ ಸ್ವಾಮಿ. I have to file report
39 list
before the court, my lord.
39 list after Dasara vacation. 37, Mr. Reddy is opposing adjournment.
My lord, ನಾ ಹೊರಗಡೆ ಇದ್ದೀನಿ ಇವತ್ತು. Kindly it may be taken on immediately after vacation, 15th only, my lord.
Relist at request made on behalf of the respondent on
1610.
My lord, serial number 36.
Obliged.
My lord, serial number 36, kindly. After vacation.
list after vacation.
36.
Inform the other side.
Please.
Inform the other side.
Page number 13, 40, 41, 42 and 43. Page number 14, 44. Page number 15, 45 to
Page
49.
number 15, my lord, 47, serial number. I am for respondent. I filed the objections, my lord.
You inform him
I inform.
at request. Relist the matter after Dasara vacation.
Much.
My lord. Serial number 46, my lord. My
Yes.
lord, I need to file one document, my lord. Kindly, may I, my lord,
Relist after Dasara vacation at request.
please, my lord, interim order is there, my lord. Kindly, it may be extended.
Order earlier grant is extended till the next date.
Great.
Serial number 45, my lord.
Yes,
Lordship, I have it this matter after vacation, my lord.
list after Dasara vacation at request.
Page number 16, 50 and 51, 52. Page number 17, 53 and 55.
My lord, one submission, my lord.
Yes.
My lord, here, my lord, I am seeking, my lord, one matter, my lord, at the end of the list, my lord. My lord, here, my lord, without, my lord, hearing me, my lord, an order is passed, my lord, by the tribunal. My lord, now the status quo is being, my lord, sought to be changed. My lord, and it is on incorrect facts, my lord, and wrong interpretation of the, my lord, the rule also, my lord. So kindly, my lord, it may be taken at the end of the list, my lord. Kindly, my colleague is there, my lord. Kindly.
When was the order passed?
My lord, some 8 days back, my lord. Once immediately I got the order, my lord, I am challenging. Kindly, my lord.
Who's the other side?
My lord, other side, my lord, is the, my lord, the government, my lord, and the private respondent.
What the serial number?
Okay, end of the list.
End of the list.
End of the
Lordship,
list.
serial number 46 is concerned.
The KIT has passed the order stating that in academic year they are transfer. No, 2023, they are obtained stay, my lordship, they are not ready to argue. English
No, no,
may
no.
be ready, my lordship, because transfer order, my lordship, since he is working as a 4 years. Whereas he is working as a graduate in
Lord,
lecture, my
my lord,
lordship, 2023 order is passed, my lordship.
my lord, precisely may I make one submission, my lord, precisely, my
My
lord. Your
lordship,
lordship,
there
my
is
lord,
a rules, my lordship, within 4 years we can transfer.
my lord, this matter, my lord, your lordship has examined and my lord, and later found, my lord, that
No, we
it
are
needs.
already filed that objection also, my lordship.
Yes, my lord. My lord, may I make one submission? Your lordship, my lord, has heard this matter, my lord, and my lord, my lord, lordship were of the view, my lord, that it requires hearing. And thereafter, my lord, after hearing for 2 times, my lord, it was adjourned. Now, my lord, the reason, my lord, why I had sought, my lord, for adjournment is, my lord, now, my lord, and my lord, I have got to, my lord, late to one, my lord, the document saying as to, my lord, that the deputation period has to be considered for transfer, my lord. The state themselves, my lord, in one of such matter, my lord, they have admitted before, my lord, the court. And my lord, that document, my lord, I need to, my lord, produce, my lord. Kindly, any day, my lord, even after vacation, my lord, if one day is not given, I'll be ready.
Even 21, he was transferred. The 4 years also come to be end, my lord.
No, my lord.
He is,
No, my lord,
he
lordship.
even taken for deputation period, my lordship. His period is over. 18
No,
years,
no, no,
1
no,
month
no,
since he is working there.
no, my lord. I have not even completed, my lord, my minimum tenure, my lord. I have established, my lord, that, my lord.
We'll have it on the opening day. Relist.
Please, please, please. Great.
Yes, yes.
For being spoken to Silamaran Sanganagoda V. Brother.
My lords, in this case, my lords, interest is not our interest. Interest bandila. In judgment, my lords, ಅದು ಇದರಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಬಂದೇ ಇಲ್ಲ. ಇಲ್ಲ ಬಂದಿಲ್ಲ 6% ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಬೇಕಂತ ಬಂದೆ.
ಫೈನಲ್ ಆರ್ಡರ್ ಇದೆಯಲ್ರಿ?
ಇಲ್ಲ ಯಾವ್ದ್ರ ನಾನು
Respond claimants are held entitled for total combined rupees 78,13,000 with interest at 6% per annum. Per annum ಅಂತ ಆಗ್ಬೇಕಷ್ಟೇ. As against the compensation award by the tribunal so and so reduced compensation.
ಅಲ್ಲ ಆಪರೇಟಿವ್ ಪರ್ಸನ್ ಅಂದ್ರೆ ಆಪರೇಟಿವ್ ಪರ್ಸನ್
ಅದೇ
ಅದು ನೆಟ್ ಕಾಪಿಯಲ್ಲಿ ತೆಗೆದು ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಇರ್ಲಿ
ಇಲ್ಲಿದೆಯಲ್ಲ 6% ಅಂತ ಇದೆಯಲ್ಲ per annum ಮತ್ತು ಪೇ ಅಂತ ಆಗ್ಬೇಕಷ್ಟೇ.
ಆಯ್ತು
For enough.
Two double zero one zero.
104 200 104 of 2022.
We'll check it, we'll check. What are the ಬೇರೆ ಬೇರೆ
ಪ್ರಿಂಟ್ ತಗೊಂಡ್ಬರ್ಲಿ.
We'll check it.
There is some upload, we'll just check. You have a look at this. There appears to be some mistake. We'll just check. I don't know whether uploading there is some mistake. We'll check it.
ಇದರಲ್ಲಿ ಎಲ್ಲಿಯೂ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ, but there is some mistake. We'll check it.
Original ಕಾಪಿಯಲ್ಲಿ ಏನೋ ಆಗಿದೆ ಅದು. ಫೈಲ್ ಅಪ್ಲೋಡಿಂಗ್ ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ಕೊಡಿಲಿ.
ಆರ್ಡರ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ಅವರು ದೇ ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಡೆಪಾಸಿಟ್ ಇಂಟ್ರೆಸ್ಟ್. ಪ್ಯಾರಾ ನಂಬರ್ 21 ಅಲ್ಲಿ ಬಂದಿದೆ 6% ಅಂತ, ಬಟ್ ಇದ್ರಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಇದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ತೇನೆ.
ಆಯ್ತು sir. ಆಯ್ತು
ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ತೇವೆ.
ಆಯ್ತು sir.
ನೋಡಿ ಕಳಿಸಿ. ಇದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಎಷ್ಟು ಸೇರಿಸ್ಬೇಕಷ್ಟೇ ಇದು ಒರಿಜಿನಲ್. ಒರಿಜಿನಲ್ ಯಾವ್ದು ನೋಡಿ, ಇದೇ ಒರಿಜಿನಲ್ ಅಲ್ಲ. ಹೌದು ಸರ್, ಟೆಲಿ ಆಗ್ತದೆ. ಇಲ್ಲ ಇದು 22 ಪೇಜ್ ಇದೆ ಇದು. ಅದು ಬೇರೆ ಹಾಕಿದ್ದಾರೆ. ಇದಕ್ಕೆ ಟೆಲಿ ಆಗ್ಬೇಕಲ್ಲ. ಇದು ಪೇಜ್ 22. ಹಿಂಗೆ ಇಟ್ಬೋದು ನಾವು. ಬೇರೆನಾ? It is brought to the notice of this court that in the operative portion of the order, rate of interest is not mentioned to be awarded towards the compensation so awarded. In para 21 of the judgment, it is observed that the claimants are entitled for 6% interest on the amount of award. Due to oversight inadvertence, it is not mentioned in the operative portion. Therefore, the claimants are held entitled for interest on the amount awarded at the rate of 6% per annum on rupees 49 lakhs 42,000. 50,000 from the date of petition till realization. Registry is directed to make necessary corrections in the operative portion and prepared award accordingly. Check ಮಾಡಿದ್ವಿ.
Number 2, government advocate.
My lords, in serial number 2 ದಲ್ಲಿ on that day my lords 50% award amount withdrawal ಮಾಡಕ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಬಟ್ that was not shown in order. ಹೌದು, ಇದರಲ್ಲಿ 120 days ಡಿಲೇ ಇತ್ತು. ಅದು ಡಿಲೇ ಕ್ಯಾಪ್ಟ್ ಓಪನ್ ಇಟ್ ಅವ್ರು ಮಾಡಿದ್ರು ಆರ್ಡರ್, ಬಟ್ ಅದೇನೋ ಬಂದಿಲ್ಲ, ಕ್ವಶನ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಆನ್ ದಟ್ ಡೇ ಮೇಲೆ 24 ಇದರಲ್ಲಿ 24 dated 24/9/2024 ಅವತ್ತು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇತ್ತು. ಅದು
ಯಾವ್ದು ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ಬರೇ ಆಫೀಸ್ ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾ
ಅಲ್ಲ, ಕರೆಕ್ಷನ್ ಮಾಡಕ್ ಇದು ಮಾಡ್ಬಿಟ್ಟು ವಿಡ್ರಾಲ್ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರು ಅವತ್ತು, ಬಟ್ 120 days ಡಿಲೇ ಇತ್ತು.
Let it come up, then it will order will be
Post
considered.
for admission ಅಂತ ಆಗಿತ್ತು 24/9
ಇಲ್ಲ, ಅವತ್ತು 50% ಸ್ಟೇ
correct.
ಪರ್ಮಿಟೆಡ್ ಟು ವಿಡ್ರಾ ಅಂತ.
ಇನ್ನ
We
ಆಗಿದ್ದು
don't know, let it come, it will, order will be passed. The counsel for the appellant submits that interim order was to have been passed in the order dated 24/9/2024, full stop. Taking note of the other past, relist the matter in the admission list. Consideration of interim prayers kept open and necessary orders, passing of necessary orders to be considered on the next date. Relist the matter on.
Seal number 3, orders matters number 3,
Hearing for the appellant and also respond in their appeal, my lord. The CH-2 has preferred the appeal. This is a long pending matter, my lord. On the point of negligence.
ಪ್ರೀತಿ ಪಾಟೀಲ್ ಬರಲಿಲ್ಲ.
ಹೌದು.
ಅವರೆಲ್ಲಿದೆ? ಬಂದಿಲ್ಲ.
ಇಲ್ಲ ಸರ್, ಬಂದಿಲ್ಲ ಸರ್, ಅವ್ರು ಹಾಸ್ಪಿಟಲ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ವೆಕೇಶನ್.
Seal number 4, RG Bushari.
Only 2 days time for weeks time granted to do the needful.
Seal number 5, PM Ghate.
Here for complaint, they were directed to file an affidavit with regard to
The lands which were already utilized for formation of road. And so according to my information, they have already surveyed the property. I think whether they have filed the report or not. Thank you.
Yes.
Because my client was called and even other the landowners, they were also called. my lord. So about more than 2.5 kilometers of the area.
Who has to file?
Respond number 2, my lord. Respond number 2 ನಮ್ಮೇಲೆ ಹಾಕ್ತಾರೆ ಸುಮ್ಮನೆ ಗೊತ್ತಿದೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಬಗ್ಗೆ ಆರ್ಡರ್ ಇದೆ ನೋಡಿ ಇಲ್ಲಿ ಸರ್ ಈಸ್ ದಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ my lord he utilize that one but he has to deposit the amount to us then we have to proceedings with the acquisition but they are not showing the any interest you will also issue warrant to the but జిల్లా పంచాయత్
Pass over, you get instruction and.
please my lord.
Pass over, no time, pass over.
My lord, I am the proxy counsel.
That's your headache. Next.
Sir, there was a direction, my lord.
No,
Wrong submission.
you ask the regular counsel to make arrangement. Yes.
Number 6, Biradar Impleading.
Respondent from yesterday filed an affidavit here. Today is this amount of rupees 5,000 which is today is paying your.
Out of 80,000.
Which is awarded in this case.
Where is
I
your
have-
respondent?
So he is due to some medical emergency with his daughter. He is unable to appear, your lordship. Next day I will keep him.
We have directed him to be present
Yes,
here.
yes, I informed your lordship. Yesterday he has been.
How much is to be paid and how much you are paying now?
Now, last date I have filed a memo regarding the earlier, in the earlier proceeding, trial court proceeding.
Correct, high court the,
High court do 5,000 monthly court, ಹೇಳಿದ್ದಾರೆ.
ಹಾ.
Arrears I will calculate your today 5,000 rupees he is paying your lordship. Today.
My lord,
Arrears, he has undertaken to file the arrears within 2 months, which is mentioned in the affidavit.
within 2 months.
2 months. Yes. That is there in the affidavit which was filed yesterday, which he shown on 26th September.
You filed the affidavit.
Yes, yesterday only filed your
Put
lordship.
it, put it.
He had been into office on 26th, he has shown that affidavit.
In a file.
I have not received
In a
copy, my
file.
lord.
Just give an office copy of it.
Yes.
Is the arrears?
My lord, 80,000 ಇದೆ ಸರ್. ಒಂದು ವರ್ಷದ್ದು.
One
Within 30 days ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್, 5th June ಕ್ಕೆ.
What is the arrears?
As per the honorable high court order, it is
ಎಷ್ಟಿದೆ arrears?
From the date of petition, I will calculate your lordship. I will calculate and submit your.
ಏನು ಉಪಕಾರ ಮಾಡ್ತಾ ಇದ್ರಿ ಯಾರಿಗೆ ತಾವು?
No, your lordship, it is.
5,000 ಕೊಟ್ಟೆ ನಾವು ಪಿಗ್ಮಿ
no.
ಕಲೆಕ್ಟರಾ?
That is not the case, your lordship. Some issues regarding, he totally is depend upon the agricultural income, your lordship.
City ಅಲ್ವಾ? When court, high court directs him. to
Yes,
appear
your
before
lordship.
the court,
I conveyed him, your lordship, the seriousness of the entire thing, but your lordship.
he must come.
Yes,
ಎರಡು
your
records. 230.
Three is not in station, your lordship. Due to some medical emergency, he is there, your lordship, for that reason.
ಇಲ್ಲ, 2:15 ಕರ್ಸಿ, we'll take him to custody, then ಗೊತ್ತಾಗ.
Number 7, Ramchandra K.
Appear for the respondent number. Matter.
I am appearing for respondent number 1, my lord.
I am for petitioner, my lord. Complainant.
But in this matter, my lord, I filed the wakalat for R1, my lord, and also filed the affidavit of the, my lord, commissioner. And, we issued the endorsement. Copies also served to the, my lord, complainant. Kindly see, my lord, annexure R6, my lord. There is a direction, my lord, Lonu Singhal Judge. To consider the representation. my lord. Page number, my lord, 7. Operative portion is, my lord, page number 10. Page number 9, my lord. Without expressing any opinion on the merits of the case, respondent 5 is directed to consider the representation dated 25/6/2019.
Consideration is
Yes,
annexed.
Yes, that is annexure R6, my lord, in my affidavit of the respondent 1. R6, my lord, dated, my lord, 27/2/2024 itself. Page number 14, third para, my lord.
What was the representation?
Representation, my lord, there is an encroachment of the, my lord, he is seeking the compensation on that. That is not the correct, my lord. We stated in the detail, my lord, in the endorsement. He not filed any objection to that during that period. His father also not filed any objection. It is, my lord, belongs to the corporation. So, my lord, we not taken that property and we removed that encroachment.
Let him come, we'll see. Relist.
Not
No,
come-
none appears on behalf of the petitioner. Relist on.
Not, my
Let
name
us
may be
see,
shown, my lord, for R1, my lord. I filed the wakalattu.
Government advocate.
Individual capacity, I filed the wakalat, my lord, for R1. But he is the before court, my lord.
No, Gaurish Kashampur. Huh?
But he is the penal, my lord, but he is the transfer to the other place, my lord. He requested me to appear.
So you will
Filed the
appear.
wakalat, yes.
In your,
I filed the wakalat.
so and so. There is appears on behalf of R1.
For.
Office to show the name of.
But his presence may be dispensed with next time, my lord.
As appearing on behalf of R1.
Please.
The R1 is present. His presence dispensed with of the present and undertakes to appear as and when he is called
Please,
upon.
definitely.
Designation Barkuri is present.
Yes, sir.
Yes.
Individual.
See number 8, AM Nagral.
Appearing for the
Application is
appellant.
filing for modification of the interim order. In connected similar matter, if 50% have been deposited, it should be, there must be uniformity in connected matter. Along with that, I also filed a
Modification.
passed by this honorable court.
Pass 24.
Page 4, there is an order, this court.
Appearing for the appellant, my lord.
Just check. I'll pass over. Just check the order sheet. On that day, no order is there. Just check. We'll pass over.
Other two matters, there is a order.
Huh?
Other two matters, there is a order. First matter, my lord, there is no order of, my lord, interim order, only directed not to precipitate it till next date, my lord. In, my lord, 20030 of 24, there was no order.
Yes.
20057 and other matter, my lord, there was a order. I have raised, my lord, ground that, my lord, under section 64, 30 plus 30, my lord, there is a limitation for reference of, my lord, by the SLO to the authority.
Now you tell us the dates.
Yes. Lots may get
Main file.
20003 of, my lord, 30, my lord, same, all are connected. my lord.
Yes. Now you take us in that first, that 20030.
Yes.
You take us act. Now you take us to the facts.
Yes. May I request, my lord, page number 9 is the order, common order passed by the, my lord, authority.
Yes.
It's date of 4/1 notification, my lord, that is, new act notification is, my lord, 29/2012, my lord. 20th September 2012, my lord.
Yes.
My lord, date of special land acquisition officer award is, my lord, 24/11/2015, my lord. 4/11/2015, my lord.
Award of LAO.
Yes.
Yes.
Lord, sir, this protest petition was filed by the, my lord, these claimants on 1/7/2016.
On
1/7/2016.
1/7/2016. Where do you get that date?
Date is, my lord, page number 11, internal page 3 of, my lord, order, my lord. Para 5, my lord.
1/7/2016.
Claimants being agreed by the assessment market value of, my lord, learned SLO filed a protest petition before the authorities.
Yes.
Lords, authority could have, my lord, referred the matter from 2016, that is 30 days. May I request, my lord, section 64, my lord?
Section
64 of, my lord, new land acquisition.
Yes, read.
Notes, any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the authority, as the case may be, whether his objection to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of the rehabilitation and resettlement order, chapter 5 and 6, or the apportionment of the compensation among the person interested, provided that the collector shall within a period of 30 days from the date of receipt of application make a reference to the appropriate authority. This 30 days, my lord, is a precedent, my lord. Thereafter, my lord,
So 30 days from 1/7 according to you.
1/7/2016, my lord.
According to you, 30 days.
Yes.
Then
Thereafter, my lord, there is exception also, my lord, proviso. Provided, my lord, second proviso, provided further that where the collector fails to make such a reference within a period of so specified, the applicant may apply to the authority as the case may be, requesting it to direct the collector to make a reference to it within a period of further 30 days. If, my lord, SLO is not deferred within 30 days, the claimants have, my lord, opportunity to seek for reference, my lords. As, my lord, in the old section 18 is there, my lord, there is no limitation for, my lord, 30 days or 3 years, 90 days there, my lord. On this ground, my lord, we have filed this appeal apart from the.
So when was the reference made?
The reference was made, my lord, may I request, my lord? Page 9 of the order, my lord. Exact date, my lord, presented on 14/12/2021, my lord. Top of the, there are 3 dates, my lords. Before, my lord, court starts, my lord.
Page
9, first page of, my lord, order of the authority. My lord.
29.
Page 9, my lord, 109. First page of, my lord, judgment. ಅದರಲ್ಲಿ presented on, first starts from presented on 14/12/2021.
14/12/2021. 21.
Yes.
Requires some consideration.
Milords, requires consideration, milords, in connected matter, milords, wherein I have enclosed the order copy also, milord, that was the very same consideration submitted by my learned friend, milords. Considering that aspect, milords, the honorable court has, the coordinate bench has passed an order stating that deposit 50% of the amount. Nonetheless, milords, it has to be kept in fixed deposit, milords.
Okay, but now on merits itself, there is some doubt.
No, milords.
21.
The other connected matter, milords, I have, which I have referred to, milords, the same grounds have been urged by the.
No, correct. But you look at now, this aspect was not, if it's, could the reference have been made in 21? Is a question that would show prima facie there is some merit. So it has to be considered.
That has to be considered, milords, but the connected matters, milords, what I am saying.
Maybe so, but now this aspect was not, may not have been noticed.
No, that has been noticed, milords. In the operative portion of the order, that has been referred to, milords.
In
Kindly
fact,
peruse
my
the
lord,
order copy.
this court has permitted to
peruse the
withdraw
order
the 25%, my lord. In that case, my lord, court has not directed, my lord. Court has directed to fix the, my lord, deposit before the, my lord, bank, my lord.
Kindly peruse, milords, the 8th line, milords, of the second para, milords. This honorable court, milords, after hearing this matter.
Second para is in regard to, my lord, the delay in filing present appeals.
Second line, thereafter. And also.
No, this, where is that point considered?
My lord, reference, milords, may I read the entire para, milords?
Yes.
Shri A.M. Nagral, Senior Learned Counsel for the appellant submits that the appeal is belated over 300 days. And the question whether the delay is beyond 120 days could be condoned as the matter is pending before Honorable Supreme Court. A submission cannot be controverted. Shri A.M. Nagral further requests for the interim order of stay contending that the respondent claimant reference before the authority is belated. This point was urged before this honorable court members. And the other day, this was submitted that in connected matters, 25% of the award was has been ordered by this honorable court, my lords. There is no, they have not placed any order wherein 25% was ordered in any other connected matter, my lords.
No, but there is no order for disbursal.
No, there is no order for disbursement.
You're saying same order will suffice.
Only thing in the second matter, it is beneficial is, my lords, in 25%
You
which
take
has been
that, you
permitted
take-
to withdraw, my lords.
You take that benefit, we'll see. IA seeking for modification of the order dated 24/9/2024 is rejected, taking note of contention raised relating to belated reference, which is a matter that requires consideration.
Another submission, my lords, if the honorable court permits.
Since the question is a question of law, it's made clear that both parties to file the written submissions as to the time within which reference is to be made in terms of section 64 and in particular reference to the proviso under section 64.
First and second provision.
First and second proviso to section 64. You get ready on the minutes.
My lords, one submission I would like to make, my lords. The tribunal was constituted thereafter, my lords. My lords, the honorable court may also direct the state authorities to as to submit a report when the tribunal was constituted, my lords.
The state also to take their stand regarding date of constitution of the authority.
Tribunal, my lords.
Authority under the
Authority. Yes, my lords.
As contemplated under section 64.
Yes, my lords.
In light of the contention of counsel for the respondent land loser, that the reason for belated reference was also due to non-constitution of the authority in time.
Please. And one more submission, my lords. In one of the matter, my lords, interim order has been, there was an order passed by this honorable court on last date of hearing that not to precipitate the matter, my lords. There is no such order for deposit of the another connect, the other.
Same order maybe, 25%,
Full stop.
20030, my lord.
Insofar as 20030 of 2024. Order code. The
Order dated 24/9/2024.
order dated 24/9/2024. In light of the order dated 24/9/2024, there would be an interim order in this appeal also on same lines. Accordingly, there would be stay of the order of the reference court subject to appellants depositing 25% of the award amount with interest before the reference court within 6 weeks from date of receipt of certified copy of the order with permission to the claimant to get release of the said amount. Full stop. Needless to state, claimant is directed to execute indemnity bond to refund the amount in case the appellants succeed.
Records may be called for, my lord.
PCR to be called.
I request for
Court.
matter may be admitted.
Respondent 2 and 3 is the government, my lord. Appellant for permission.
2 and 3 is government may be directed take.
I'll take notice to
GA accepts notice for respondents
2 and 3.
in which one?
In first matter, my lord, that is.
First and third.
00030 of 24.
In serial number 8 and
10.
8.1 and
10 is
8.2, my
ordered.
lords.
8 and 8 point?
8.1 and 8.2, my lords.
Other cases, he already taken notice, my lord. In
In
this
eight.
case, my lord, I am not taking.
In 8. Then what about 8.2? Who is R2?
Government.
R2.
Who's R2?
Nobody. Right, 851. that is 851.
R2 is, my lords, another claimant, my lords. I take,
Claimant.
I'll undertake to file power on there.
General counsel so and so. undertakes to appear for the second respondent in 8.2. Yes,
It's 8.1, my lord, the delay application is shown, my lord. Delay is kept open.
in 8.1, IA 1 of 2023 is kept open for consideration in light of the legal question still to be adjudicated in proceedings pending before the apex. Yes.
Number 9.
Nine, my lord, appear for the appellant, my lord. Order, appear for the appellant.
For the respondent.
Order, there is a 3 objections, my lord, I will
Ten.
note the, my lord, submission. That regarding objection number 1, my lord, in the judgment, my lord, that a special land acquisition officer, special land acquisition officer is the party. But in the award, my lord, is not there.
In light of the office objection, serial number 1 is kept in abeyance, subject to steps to be taken to have the same rectified before the trial court in due course.
Lord, so far as second objection is concerned, my lord, respondent number 3, my lord, in the judgment is there, my lord, in the award is not there.
In light of the discrepancy between the judgment and award
Please,
regarding parties arrayed, office objection at serial number 2 is kept open.
please. 3 is the concern regarding factor, my lord. In the judgment, my lord, factor number 1 is correct. But in the award, my lord, factor number 2 is mentioned. That is wrong.
He said office objection is also kept in abeyance. Full stop. It is clarified that appellants to take necessary steps to have the discrepancies rectified and furnish fresh copy after rectification of such discrepancy in due course.
Please.
Yes,
There is a, my lord, delay, my lord, that is, stay is there, my lord. IA for stay, my lord.
how many days delay? Beyond 120.
Please.
Yes.
Number 10.
My lord, in this case, R2 and on behalf of SS Halali, my lord, already get instruction within 3 weeks I am complying, my lord. 3 weeks time. My lord.
Realist on.
4110.
Publish.
Serial number 11. Shivanand Patil.
Notice with regards to.
Notice to mention the reason. First time.
One and 3, na? Office has put up a note. Site. This was issued. In the cover, postage cover submitted by the.
This is with regards to that your lordship had argued before your lordship, where part of the suit was dismissed only against a particular defendant under 7 rule 11D ನಾಗ.
ಹಂಗ್ ಬರಲ್ಲ ಅದು.
ಅದು ಬರೋದಲ್ಲ ಅಂತ ಅದೇ ಹೇಳಿದ್ರಿ, ವಿಲ್ ಕಂಪ್ಲೀಟ್ ಇಟ್ ಬಿಫೋರ್ ವಿ ಗೋ ಅಪ್ ಅಂತ ಹೇಳಿದ್ರಿ, ಅದಕ್ಕೆ ನಾನು ಇಷ್ಟು ಫಾಸ್ಟ್. ಯಾಕಂದ್ರೆ 7 rule 11D ನಾಗ if you have to dismiss the suit, dismiss it in entirety or don't dismiss it. ಅದೇ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು.
Consider the appellate files memo. Stating this may be dispensed to this way. Please. To respond number 1 and 3 may be dispensed with. At the risk of appellant, notice to respond number 1 and 3 is dispensed with as well.
What do you say?
Today I filed wakalat for R7.
No, correct. What do you say on the
What
legal
you say on the legal aspect?
position?
Plaint cannot be rejected partially. It is settled principle of law. But he has dismissed suit, rejected the plaint partially. Is it permissible? Nim prakara.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಇದೆ, ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಕೋಆರ್ಡಿನೇಟ್. ಜಸ್ಟಿಸ್ ಬಿ ವಿ ನಾಗರತ್ನ ಅಂಡ್ ಜಸ್ಟಿಸ್ ನಿಜಗಣ್ಣ ಅವರು.
ಇಲ್ಲ ಟೆಕ್ನಿಕಲ್ ಎಕ್ಸ್ಪರ್ಟ್ ಅಷ್ಟೇ ಅದು.
ಪ್ಯಾರಾ ನಂಬರ್ 12 may be looked in.
Yes, only.
Para number 12.
Today I have filed wakalat. I praying for 2 weeks time to file a statement of objection. 2 weeks time for filing statement of objection. ಇದಕ್ಕೆ
RFI ಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರುತ್ತೆ.
RFI ಅಲ್ಲಿ ಇದಕ್ಕೆಂತ ಅದ
First appeal ಇದೆ.
ಬರೀ ರಿಜೆಕ್ಷನ್ ಆಫ್ ಪ್ಲೇಂಟ್ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ, ಪಾರ್ಸಲ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಎಲ್ಲ ಏನ್ ಮಾಡ್ತೀರಿ ಅಲ್ಲೇ ಮಾಡಿ ಕೆಳಗಿನ ಕೊಟ್ಟಲ್ಲಿ. Apparently that order is wrong. Partial appeal reject ಮಾಡಕ್ ಬರಲ್ಲ. Order 7 to 11 scope ಅಲ್ಲ ಅದು. ಇವನ್ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ.
It will only have to go back.
Supreme Court
My lord.
also says.
I undertake to file wakalat on behalf of R2, R5, R6 and R8, my lord.
ಹಾಕಿ ವಕಾಲತ್ ಹಾಕಿ. We'll pass orders today.
Any date after vacation?
ಬೇಡ.
See, it's only a legal question.
ಲೀಗಲ್ ಕ್ವಶನ್ ಇಟ್ 2018 ಸೂಟ್ ಈಗಾಗಲೇ 6 ವರ್ಷ ಆಯ್ತು. ಅಲ್ಲಿ ಹೋಗಿ ನಿಮ್ದೆಲ್ಲ ರೈಟ್.
They're only sending it back
We'll send
for
it
the
back.
retrial
Please.
on the entirety. Insofar as the contention as regards 7 and 8, it will be kept open.
Please.
ಅಲ್ವಾ?
I need to go through
So and so advocate undertakes to file wakalat for respondent number 2, 4,
2, 5, 6 and 8, my lord.
2, 5, 6 and 8. Sanjay Kulkarni for us. Heard the arguments of both the side. With consent of both the side, heard the arguments of both the side. Next. The appellants, being the plaintiffs in OS number 48 of 2018, have preferred this appeal, challenging the rejection of their plaint by orders dated 8th August 2024, passed in OS number 48 of 2018 by the Senior Civil Judge and JMFC Chittapura. Next para. According to the plaintiffs, they filed a suit for partition alado.
Yes, suit for partition and separate position.
They filed a suit for partition and separate possession of the social property, stating that the scheduled properties are the joint family ancestral properties. Full point. They also have shown the pedigree in the plaint and also have shown the same in the appeal memo. Full point. It is stated that the defendant number 7 company entered into an agreement for sale with the defendant 5 and 6 to purchase suit land bearing survey number 404 and 405, and therefore they are made as the parties. Full point. It is stated that the social properties are the ancestral joint family properties, and the plaintiffs and defendant 1 to 6 have got a share in the same. Full point. The plaintiffs and defendant 1 to 4 are considered the joint family and succeed to the properties. Full point. As there was a refusal on the part of the defendants to effect the partition, therefore they were constrained to file the suit for partition. Fine. Next para. Before the learned trial court, if 1 and 5 appeared and admitted the relationship, but denied the status of the scheduled properties as a ancestral joint family properties. Full point. It is further contended that suit of the plaintiff is not maintainable. Full point. They also contend that During the pendency of the suit itself, the defendant number 7 filed IA number 11 before the trial court under Order 7, Rule 11AD, read with Order 1, Rule 10, Bracket 2 of CPC, and prayed for rejection of the plaint or delete the properties at item number 7 and 8 shown in Annexure 1, that is who properties. Fine. The said application was resisted by the plaintiff, but the learned trial court has allowed the said application and rejected the plaint partially. This is how now the plaintiffs are before this court challenging the said impugned order passed by the trial court, rejecting the plaint partially. Next para. Along with the appeal memo, nothing but it is submitted by the counsel for the appellants that by virtue of the provisions of Order 7 to 11 of CPC, plaint, there cannot be any partial rejection of the plaint. Fine. He submits that it was a suit for partition. Fine. In respect of two properties, the plaint came to be rejected, which apparently is wrong. Fine. He further submits that as the scheduled properties are the joint family ancestral properties, plaintiffs and defendant number 1 to 6 have got their legitimate share in the same. Fine. But the trial court, in respect of the two properties mentioned in the application, that is suit lands being survey number 404 and 405, has rejected the plaint, which is wrong. Fine. In support of his submission, the learned counsel for the plaintiffs is so and so relied upon a judgment of a court and bench of this court in RFA number 1002 of 2016 between Srimati Shantamma and others versus Srimati Shivaram Reddy and others, decided on 6th August 2019. So also, he submits that the impugned order requires interference by this court. Next para. As against this submission, the learned counsel for the respondents justified the rejection of the plaint filed by the plaintiffs in OS number 48 of 2018. It is contended that as the said properties were the subject matter of agreement of sale, therefore the plaint was rejected of the trial court partially. It is further contended that it's further submitted that the learned trial court is right in passing the impugned order. It is prayed by the respective respondents, counsel for the respondents, to dismiss the appeal. Next para. Any of the rival submissions of both the side, the following points arise for our consideration. CPC put it. Next. Whether the learned trial court is right, it is justified in rejecting the plaint filed by the plaintiffs partially. Next para. Evidently, in this case, the contesting defendants filed an interim application seeking rejection of the plaint as two properties were not the properties of the family of the plaintiffs and defendants and are included. They prayed that the plaint may be rejected or the said properties be deleted from the list of the scheduled properties. The contesting defendants invoke the provisions of Order 7, Rule 11 of CPC. The provisions of Order 7, Rule 11 of CPC reads as under type money. On scrupulous reading of the provisions of Order 7, Rule 11 of CPC, it mandates that plaint can be rejected only under the grounds so stated in Order 7, Rule 11 of CPC. Fine. Here in this case, partially the plaint was rejected. Fine. That means when a case falls under Order 7, Rule 11 of the CPC, the plaint is rejected unless in respect of cases covered by Clause B and C and defects are removed. Fine. It is the settled principle of law that plaint cannot be rejected partially. Full point. But in this case, the Lerner trial court has rejected the plaint partially. Full point. Now the plaintiffs are questioning the same. Next, a coordinate bench of this, in a judgment of the court bench of this court stated supra, in para 12, it is observed as under. You can type. Next, as it is a settled principle of law with regard to the rejection of the plaint, and the plaint can be rejected partially. From the observations made in para 12 of the said judgment are aptly applicable to the present facts of the case. Full point. In the instant case also, the trial court has rejected the plaint partially or directed the plaintiff to delete two properties from the schedule.
And defend number 7. And defend number 7.
And defend number 7. And defend number 7.
Two properties and defend number 7.
Which is not permissible. Even the trial court cannot give such a direction as plaintiffs are claiming these their alleged legitimate share in the scheduled properties on the ground that the suitable properties are the ancestral joint family properties. Therefore, apparently, the impugned order suffers from illegality and rejection of the plaint by the plaintiff is improper. However, the rights of both the parties are to be kept open. The trial court has to decide the suit on merits by giving opposition to both the plaintiffs and defendants. With this issue, the point for consent is answered against the respondents and in favor of the plaintiffs. Accordingly, we pass the following order. Appeal is allowed. The impugned order dated 8th August 2024 in OS number 40,018 by the senior civilian JMFC Chittapur is hereby set aside. The matter is remanded to the trial court for disposal in accordance with law. Full fund. All the rights of the plaintiffs and defendants are kept open.
Much.
Please.
Number 12, Hemail Kulkarni.
But in this matter, my lord, I'll take notice for R2, my lord. We received the GO, my lord, preparing the appeal against the order of the London Single Judge.
Government advocate accepts notice for the second respondent at request to release the matter on date.
2210.
Please.
Number 13, Ganesh Chubasandra Kalaburagi.
In this case, you are being accused by the order. The probate issued by the court below. This petitioner appellants are before this court. The office have raised objections regarding filing an application to permit the appellant to sue the case. I will file that necessary application, Your Lord. One application is to permit the appellants to sue this appeal as they were not party before the trial court, Your Lord.
List after the vacation.
Yes.
I have to file yours. I will file application.
Paper publication tondra.
Yes,
Paper publish tobekidike.
yes, I will file. Because much.
Yes.
14, Lepai Road.
And it may be taken at 230 minutes. Page number 90.
Pass.
Still number, hearing and interrogatory application, number 15, Shukumar Kallur.
My lord, the matter has to be heard.
Relist.
The
After, we'll have it, relist. After the.
formally, it may be admitted. Formally, it may be admitted and
The
posted.
Impleading application in.
Admission, I will.
No, there's some interlocutory applications are there.
The one submission, my lord, the matter is covered by the apex court judgment and division bench decision. Because if the court disbelieves the agreement of memorandum, all the sharers have to be included in the suit, my lord. That is not done. And other two properties are also not included in the hotspot. That is why the court, the plaintiff case is itself is that there is a partition in the year 1990.
Then we'll have it in the same stage after vacation letters.
Yes, my lord.
Relist the
Last
matter.
week will be,
Relist the matter
last week the any date.
in the week commencing from.
Yes, my lord.
Yes.
Bill number 16, DG Chavashetty.
Delay, sir, 9 days delay in filing the appeal notice. Suit for specific performance of contact. The suit is dismissed on the ground that exhibit dispute to the exhibit P2 registered agreement of deed. The registered agreement of deed that was disbelieved by the trial court and dismissed the suit on the basis of that evidence says that no amount is not received by the dependent on the oral evidence, but registered agreement is there. That was not considered by the appellate court, trial court.
In the registered agreement,
Exhibit P2,
but the court gives a finding that you have not established
Yes,
passing
yes,
of
yes,
principle.
yes.
Notice ಹೋಗಲಿ delay ಇದೆಯಲ್ಲ.
It's
Notice.
and stay may be considered, but
Huh?
in the meanwhile, at least status quo may be granted. Otherwise,
ಇಂಥ status quo ನೀವು ಎಲ್ಲಿ ನೆಟ್ ಕೇಳಿ ನಾಟ್ ಎಲ್ಲಿ ನೆಟ್ ಕೇಳಿದೆ.
injunction ಕೇಳಿ.
ಹೌದ್ರಿ.
Please.
ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಇಂತ ಇಂಜೆಕ್ಷನ್ ಇತ್ತಾ?
ಇಲ್ಲ.
ಅದೇ. Notice of file number 192 along with appeal memo to the respondents.
Bill number 17, Satyaram Pawan Kumar.
My lords
Yes.
had heard this matter the other day, where there is a road between the two plots, and the learned single judge has now overturned the order of the authority without considering the appeal and the regular second appeal filed before this honorable court, where the dismissal of the earlier suit, it is held by this honorable court in the regular second appeal, that the dismissal of the earlier suit would not come in the way of the authorities taking action.
No,
Kind-
now, correct, now, is there any interim?
That your lordships had posted this today for considering the interim order, because my friend Mr. Mantesh Patil had sought for some time that day.
He appears for
He
R1.
appears for the writ petitioner, the
He is
original
the
writ petitioner.
contesting
He
party.
is the contesting party.
Pass over, you bring him, Bill. Pass over.
Bill number 18,
My lord, I'm the appellant in this case, my lord.
Yes,
My lord, in the last occasion, my lord, the court has directed to genuinity of the marks card, my lord, have directed.
Genuineness of the marks card. Last time, government educate was to various.
Gopal Krishna, kindly pass out.
pass over.
3 years coming.
ಒಂದ್ ನಿಮಿಷ ಕೊಡು, ಕೊಡು. ಕೊಡು, ಕೊಡು.
ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರ ಅಂತ ಹೇಳಿ ಒಂದು ಇದು ಇರುತ್ತೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ DC can consider my lordship.
Huh?
After application is filed, my lordship.
No, no, you must tell us the facts. Only you know the facts, we don't know. So you just tell us briefly what the facts
My
are and
lordship, whereas
what is the query that we had asked you.
Respondent number 5 filed application when while filing the applications, he has mentioned 8 standard application.
Respondent number 5,
5 minutes.
not respondent number 5, respondent
Number 9, my lord. 9, my lord.
9, she has filed application, my
Now,
lord.
respondent number 9 had filed an application stating she had cleared 8th standard.
8 standard, when while she was filing application, my lord.
Actually, she had completed,
9 standard, my lord.
she had completed.
Subsequently, that was
What-
placed before the DC, my lordship. ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾಗ then they are going through that DC has got power. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರು ಸಹಾಯಕರು ಕಾರ್ಯನಿರ್ವಹಣೆ ಯಾವುದೇ ನ್ಯೂನತೆಗಳ ಬಗ್ಗೆ ದೂರುಗಳು ಸ್ವೀಕೃತಗೊಂಡಲ್ಲಿ ಅವುಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಇವರ ಸೇವೆಯಿಂದ ವಜಾಗೊಳಿಸುವ ಅಧಿಕಾರ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ, ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗೆ, ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಉಪ ನಿರ್ದೇಶಕರು, ಮಹಿಳಾ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಇಲಾಖೆ ಇವರಿಗೆ ಇರುತ್ತದೆ. They can modify, my lordship. ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರ DC has got power, my lordship.
No, no, now the 9th respondent Sumitra
Mitra,
and the appellant
appellant,
Sudharani,
Sudharani,
both have
Yes.
completed 9th.
9th standard.
Both have
But she
completed.
scored more than
Who has scored more?
Sudharani.
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 Appellant.
Appellant, my lord.
And that was placed before the principal also, my lordship, ನೈಜತೆಯ ಬಗ್ಗೆ That is also inquired by the respondents, my lordship, headmaster. After that, that is, order is passed, that is certified issued by the mascot, that is ನೈಜತೆಯಿಂದ ಕೂಡಿದೆ ಅಂತ ಹೇಳಿ. There is,
Correct. So now what is the single judge held?
single judge is that stating that, my lordship, while application filing,
It
you are
was
taken 8 standard.
8th standard.
So subsequently you are produced 9 standards.
Correct, correct. So now it doesn't make a difference even if
Even
it
if
is
that,
taken into
yes,
account,
my
it
lordship.
doesn't make a difference.
No, there is a deputy commissioner has got power, my lordship, as to ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರ ಒಂದು authority.
No, correct. Now, suppose they've declared 8th standard, the ninth respondent and ninth, huh?
No, my lord. I am.
My lord,
respondent. I am respondent of the ninth.
No, you tell us parties in the writ petition. Now the,
Applicant has to be misguided. It is 8th
Just-
standard
just
in
one
application, my lords.
just 1 minute.
Please.
Now this Sudharani, she had mentioned 8th, isn't it?
Yes.
Sudharani had mentioned 8th pass in the application.
Please, my lord.
However, she had completed 9th standard.
Annexure, kindly see that.
No, just
in-
1 minute, I'm asking
Please,
you the
please,
fact.
please.
Now you go to the cause title in the writ petition, page 28. Now the petitioner is 9th standard pass, Sumitra. Correct?
Yes, please.
So she challenged appointment of Sudharani
Sudhara.
on the ground that Sudharani had declared in her application 8th pass
8th pass,
and was selected, though the petitioner was 9th pass.
9th class.
So that's the ground of challenge.
Please, my lord.
That's the ground of challenge.
First list is my name. Sudharani name is, Sumitra name is first list, and second list he was implemented of the in Sudharani. First list ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಬಂದಿದೆ.
You appear for
the
whom?
provisional list,
Appear for
appellant has
respondent
not a
number.
provisional list, my lord.
No, no, just 1 minute. Now you appear for Sumitra or Sudharani?
Sumitra, my lord.
Sumitra.
Respondent number 9, my lord.
Just 1 minute. So now the Sudharani was declared selected
Please,
eventually,
please,
which you are challenged.
please, I have challenged.
Uh,
When I have in first list ನಾಗೆ ಬಂದಿದ್ದ ತಕ್ಷಣ ನಾನು objection file ಮಾಡೀನಿ.
No, correct. So now the single judge has rejected on what ground?
It is qualification ಅವ್ರದ್ದು ಕರೆಕ್ಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
That's
ಅವ್ರ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಆನ್ಲೈನ್ ನಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಗಳನ್ನು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Number 13.
My lord, the court has considered that. May I submit, my lord?
Yes.
My
Yes.
lord, court has single judge, my lord, and at the last date, ನಂತರ ಇವರು ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ. So for that,
Correct.
ಅಂತ ಇದು there are allow the petitions, my lord. But
now
my
who's
contention,
Now.
In this case, what happened, the appellant before this court, she has not filed any objection before single judge or not contested the case. Subsequently, order is passed, she filed review petition, and then when review was dismissed, then she came and filed this act, writ appeal, my lords. She want to say something, she has to file objection, my lords. It has to go back, my lords, let him to file, we are.
No, my lord. My lord.
And
In
reasoning
the
is.
presently no,
My lord, applicant has to be education is illegal, my lord.
You know, how do you?
Please, I will prove that, my lord. I will prove that. It is certificate.
My
of
lord.
the- My lord, kindly see that in mass card, 2 mass card has to be verified. Kindly, 2 mass card ಇದೆ. ಅವು 2 mass card ನ verify ಮಾಡಿ. Kindly see that, my lords. ಒಂದು ಮಾಸ್ ಕಾರ್ಡ್ ಇದೆ, ಮಡಚಿರೋದು ಇನ್ನೊಂದು ಮಾಸ್ ಕಾರ್ಡ್ ಇದೆ. 2 ಮಾಸ್ ಕಾರ್ಡ್ ನ ಬೇರೆ ಬೇರೆ ಪ್ರೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇನ್ನೊಂದು ಮಾಸ್ ಕಾರ್ಡ್ ಅಲ್ಲೇ ಮಡಚಿರೋದು ಇದೆ. ಮಡಚಿರೋ ಈ ಸೈಡ್ ಇದೆ, ಅಲ್ಲಿ ಈ ಸೈಡ್ ಇದೆ. ಮಡಚಿರೋದು ಕಂಟಿನ್ಯೂ ಇದೆ.
No,
ಒಂದೇ ಮಾಸ್ ಕಾರ್ಡ್ ನ ಎರಡು ಮಾಸ್ ಕಾರ್ಡ್ ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಮತ್ತೆ ತಾಯಿ ಹೆಸರು ಕೂಡ ಲಲಿತಾ ಅಂತ ಹೇಳ್ತಾರೆ, ಪುತ್ಳಾಬಾಯಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Okay, you examine it, Gopal
Please,
Krishna.
Please, my lords.
You examine.
my lord,
ಸ್ಕೂಲ್ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ 2004 ನಲ್ಲಿ ಯಾರು ಬರ್ತ್ ಆಗಿದಾರೋ ಇವ್ರದ್ದು 2013 ನಲ್ಲಿ ಹಾಕ್ತಾರೆ.
No, you examine.
Please, my lords.
You get instructions and examine.
my lord,
File
Please,
this
I
along-
file the objection, my lord. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ನಾನು.
Just file
Please,
it along
please.
with the memo.
Memo.
I'll
file
direct
objection.
him to look
Please.
into it.
Please,
Yes.
please,
So this one,
please.
and which is the other one?
ಅದರ್ ಒನ್
Yavdu?
ಅಲ್ಲೇ ಇದೆ ಮೈ ಕೈಂಡ್ಲಿ ಮಡ್ಚಿರೋದು ಇದೆ ನೋಡಿ, ಮಡ್ಚಿರೋದು ಕಂಟಿನ್ಯೂ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ.
Let him to file
ಅಲ್ಲಿದೆ ನೋಡಿ.
documents
ಅದನ್ನೇ
ಮೇಲೆ
ಮಾಡ್ಸ್ಬೇಕು ಅದಕ್ಕೆ.
ಹಾ.
ಬರ್ತದಲ್ಲ,
So-
ಬ್ಲ್ಯಾಕ್ ಫೋಟೋ ಕೊಡ್ತೀವಿ ನಾವು.
ಅದು ಇನ್ನು 20 ವರ್ಷದ ಹಿಂದೆ ಡಾಗ್ ಇಯರ್ಸ್ ಅಂತಾರೆ.
ಹೌದು.
ಡಾಗ್ ಇಯರ್ಸ್ ಅಂದ್ರೆ ನಾಯಿ ಕಿವಿ ಅಂತ. ಇವಾಗ ಸ್ವಲ್ಪ ಅಡ್ವಾನ್ಸ್ ಆಗಿದೆ, ಪೋಸ್ಟ್ ಇಟ್ ಅನ್ಸ್ಬೇಕು.
ಇದೆಲ್ಲ ಇಂಥದ್ದು ಇದೆ ಅಲ್ರಿ.
ಹೌದು.
My lord,
ಇದು ಒಂದು
ಇಲ್ಲೊಂದು ಬೇರೆ ಇದೆ. ಈ ಕಡೆ ತಿರ್ಸಿ ಮೇಡಮ್, ಇನ್ನೊಂದು ಪ್ಯಾರಾನಲ್ಲಿ ಇದೆ. ಅದು ಸಿಂಬಲ್ನು ಬೇರೆ ಇದೆ. ಅವ್ರು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಂತ ತಿದ್ದಿದ್ದಾರೆ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ. ನೀವು ನೋಡ್ತಾ ಇರೋದು ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ.
post it ಹಾಕ್ತಾರೆ.
ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ
my lord, kindly see the impugned order in the writ petition, my lord, annex J, page number 76, my lord.
Let us see, he's giving some certificate, let them find out, next date we'll decide.
My lord, kindly consider interim prayer, my lord.
No, let us see. He's saying that your qualification itself is bogus.
No, my lord, the, alla.
Let the government verify.
I am agree, my lord. Another things, my lord.
We'll keep it open, let us see, we are not deciding. Anything we say
Yes.
will prejudice your case.
ಅಲ್ಲ ಅವ್ರು ನೋಡ್ಲಿ, ಸ್ವಲ್ಪ ಕೋಟಿ ಗಮನಕ್ಕೆ ಬರ್ಬೇಕಲ್ಲ ಮಾಸ್ವಾಮಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೈ ಲಾರ್ಡ್ಸ್, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಅಬ್ಜೆಕ್ಷನ್
No, that we'll see, that's on merit, sir. Ask them to verify.
Yes.
It is a contention raised on behalf of respondent number 9.
9
Nine.
ಪ್ಲೀಸ್.
That the certificate, the marks card of the appellant is required to be verified by the government. Insofar as there are two marks cards
ಪ್ಲೀಸ್
with different marks,
ಡಿಫರೆನ್ಸ್.
with different.
Same schools, same mask card, two mask card has to be produced on the investigation officers.
ಅಲ್ಲ, marks different ಇದೆಯಾ?
Different ಇದೆ
With different marks.
mask card and
Same is filed along with the memo. AG is directed to obtain necessary instructions regarding the two marks cards, copies of which are enclosed along with the memo. You file only these two, don't give anything else.
no, my lord, it is I will produce on this TC and register of the admission register
Okay, file along with memo and
along with memo documents.
ಇವತ್ತೇ ಹಾಕಿ.
Please, madam.
My lordship,
ಏನ್
single
ಬರ್ತಿದೆ?
J.
Memo which pertain to the appellant and is asserted by respondent number 9 to be not genuine. Memo with
My lord,
is filed by 9th respondent.
my lord,
is taken on record. Yes,
my lord, consider interim prayer, my lord.
so let us see, next date I'll keep it open. Consideration of interim prayer is kept open.
ಮತ್ತೆ ಅವ್ರನ್ನ ಕರ್ತೀನಿ ಅಂತ ಹೇಳಿ ಇದನ್ನ ಮಾಡ್ತಿದಾರೆ ಮಾಡ್ಲಿ.
Let us see,
Still the matter
let us
is disposed, kindly see, you can continue, my lord.
Let us see.
ಅಲ್ಲ, ಅವ್ರನ್ನ
The next-
ತೆಗಿತೀನಿ ಅಂತಿದ್ದಾರೆ, my lord, still ನಾವು working, my lord.
Let us
ಇಲ್ಲ,
see.
at least status quo, my lord, to maintain her, my lord.
Who's working as on date?
No working.
Huh?
I am not.
Appellant, still appellant working, no, my lord, appellant is working, my
Has
lord.
to be not working and I am also not working.
Status quo.
No, my lord.
Let us see on the next date
Please,
release the matter on short date.
please. 10. Please.
19 ರತ್ನ ಶಿವಗಿ ಮಠ್
Date, my lord.
31st. 21st.
21st.
Please.
Yes.
Sir, ask me kindly see annex A, my lords. That is notification. Why I am bringing to this notice, my lords, since the learner single has dismissed the writ petition to approach the DRT, since my property is not included, you will ask me kindly see annex A.
No, who appears for the bank?
Bank, I served the copy upon the Malabadi
Okay.
learned council.
Pass over, you bring him. Pass over. Next.
Sir, last occasion he appeared and sought for adjournment.
No, we have not shown in his name, we have not shown. Otherwise, we'll show his name and fix a date.
Yes, in his presence only date was fixed, madam.
Office to show the name of Learned Counsel Venkatesh Malabadi.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ urgency ಅಂದ್ರೆ they go on with auction proceeding.
No, otherwise you bring him, we'll pass over, you bring him.
Yes, madam, I'll.
Pass over.
Number 20, Nitesh Padyal.
Lordship. Very short question is involved in this case, my lord.
What is this impleading application?
Impleading, yes, my lord, that was the inadvertence on my part. When the yesterday matter was called, my lord, originally two petitioners were there earlier.
Yes.
Insofar as petition number 1 is concerned, my lord, she has not pressed and it was dismissed. In the original order, my lord, which is impugned herein, that the dismissal has not been referred to.
That is Suchitra.
Huh.
That petition was dismissed against.
Yes, my lord. That was not referred to in the impugned order. It is for that reason the honorable bench was pleased to say that move an application that was not referred in the order. Now also, your lordship may kindly have a glance.
No. Now you get it rectified, rectify the cause title before the single judge. We'll continue with the proceedings.
No, my lord, the time limit has been given.
No, that we'll consider.
Please.
What I'm saying, you are saying
Yes.
that the first petitioner Suchitra,
House.
petition was dismissed against Suchitra, but it was not noticed while passing the final order.
House. His lordship was pleased to sole petitioner antanta bandide. Your lordship a kind. Para 3 ಅಲ್ಲಿ.
No, what is the office objection raised?
Office objection is note is she has not been made as a part.
Correct. So this you get it rectified.
As
You get it rectified before the single judge. We'll keep that office objection in abeyance. Office objection raised, we'll keep it in abeyance. So what is the main matter you?
Main matter is, my lord, the petitioner was appointed on.
Why did you file impleading now?
No, yesterday his lordship directed me.
Why should you file impleading?
Adi ಬೇಕಾಗಲ್ಲ, sir.
You have to get it rectified before the single judge.
No, even rectification may also may not be
Last
required.
title you will have to get rectified. You go
I
to,
will add that party, my lord, as a respondent if your lordship.
why should you add?
Adhe, sir.
Now you are saying, let me understand if what you are saying is correct. You are saying the petition filed initially by Suchitra and Ravishar.
House.
Suchitra came to be dismissed during the pendency of the
House.
proceedings.
Yes, madam.
So finally, final order only pertains to Ravishar.
Yes.
Isn't it?
House.
So now the final order, there is some mistake in the cause title. Cause title mistake is there because both are mentioned. Or at least there should have been an observation petition is dismissed. So you get that rectified. There's no necessity to implead that person if the petition is dismissed.
House.
Now you appear for whom? You appear for
Petitioner.
in the writ petition.
ಅಲ್ಲಿ ಒಬ್ಬರದೇ ಬಂದಿದೆ ಸರ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ.
You appear for whom in the writ proceedings?
Both the petitioners, my lord. One petitioner in the impugned order, my lord. Only one name is appearing.
In the
Her
impugned
name has been deleted, my lord.
correct. So you get it rectified.
Her name has already been deleted.
ಎಲ್ಲಿ?
ಇದೆಯಲ್ಲ. ಇಲ್ಲ ಬಂದೆ ಒಂದ್ ನಿಮಿಷ. ಇನ್ನಲ್ಲ. I will have to get it rectified. Please.
So which is that office objection? We'll keep it in abeyance.
Please.
Is it correct?
Yes. ಇರ್ಲಿ ಅದಿರ್ಲಿ ಅದು. ಸೋಲ್ ಅಂತಂತನೂ ಬಂದಿದೆ ಸರ್.
ಅಲ್ಲಿ correct.
Please, yes, I understood. I follow.
Now unnecessary for impleading.
ಹೌದು.
It will simply delay and not necessary because that person is already according to you.
ಹೌದು ಸರ್. She has already resigned and she is not interested.
IA2 of 24 is kept in abeyance. Senior counsel appearing for the appellant submits that the writ petition in the writ proceedings.
ಈ ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ಅಲ್ಲಿ ಇಲ್ಲೇ I will add.
Cause title change. It's
ಸರಿ.
submitted by learned senior counsel appearing for the appellant that the petition against as regards Eva Suchitra.
Yes.
came to be dismissed.
Out.
However, the said aspect is not adverted to in the order,
Order, house.
in the impugned order.
Yes, madam.
Full stop. If that were to be so, necessary clarificatory order to be obtained by moving the learned single judge. Yes, now what is the main matter?
Now, main matter is, my lord, your lordship may kindly annex your B, my lord, in page 45. In page 45, my lords. I was appointed, offer of appointment to the post of tutor in ESIC Nursing College, Kalaburagi and so and so. First item number, my lord. The appointment is purely on contract basis, initially for a period of 1 year from the date of reporting, which may further be extended for a period of 3 years or on satisfactory working up to a maximum period of 3 years. And my lord, second condition is also same, contract basis. And fourth condition, what I am trying to persuade your lordship is, I was not appointed against any permanent vacancy. My appointment was only against on contract basis.
Now you serve notice on the respondent, will hear the matter.
Allah, sir, your lordship may kindly.
No, now the single judge said jurisdiction point, we have to hear.
No, my lord, two more judgments of
No,
this
no,
honorable
please
court.
correct, but we'll hear it in the presence of the other side.
Allah, sir, your lordship may kindly.
No, that aspect we have to hear in the presence of the other side.
Allah, sir, your lordship may kindly have a class.
No, that may be so, but let's hear the other side also.
That will be lapsing. I have sent my client to Bangalore also. There, after approaching designated senior and most senior advocate, he has advised to prefer the appeal here only. That will not be maintainable before the CAT. 2 judgments, my lord. Same matter.
Who appears for the other side?
Yaru? Sanjeev Kumar.
Ah.
2 matters, my lord. Same matters.
I'll
my lord.
pass over, you bring him, pass over. You give him a copy, pass over. Yes, yes. Next. Give him a copy, pass over.
Seal number.
How copy put? Yes. Pass.
Seal number 21.
You give him a copy of that. Pass. Yes.
21 government advocate.
But appear for the appellant, my lord. More than, my lord, IACD may be kept open, my lord. IFR stay may be considered.
Beyond 120 days, same order. Yes, next.
Seal number,
In serial number 21, I will undertake to file wakalat.
So undertakes to file
Normally,
wakalat for the
Respondent 1 to 7.
respondent 1 to 7. Yes, next.
Seal number 22 government advocate.
22, my lord, IA may be allowed.
Delay may be
CD, my lord,
condoned.
within the,
IA
yes, ma'am. Within 60 days, my lord.
plus 60.
Delay may be condoned, lordship.
No, just one. Act for that. Which section?
24, my lord.
74.
74. Appeal to the High Court. 60 days from the date of award.
Does it come, just tell us the dates.
First 60 days, my lord, then plus 60 days.
So the date of the order of the authority, reference court is
Award, my lord.
19/4/23. 19/4/23.
Please.
Appeal is filed on 21 November 23.
It is filed on, my lord, 12th October 2023, my lord.
It has to be kept open.
Please.
Because while calculating, now it comes exactly to 120 days.
More than, my lord.
Allah,
See, that is there, my lord, in the award kind is 74, my lord.
Huh?
First 60 days from the date of the award, my lord, 74, my lord, kind is. Acquiring body of any person aggrieved by the award passed by the authority under section 69 may file an appeal to the High Court within 60 days from the date of the award. From the date of the award, my lord, judgment will be passed, my lord, initially. Thereafter, my lord, award. Then, my lord, proviso, my lord.
It's exactly 120.
ಆದರೆ Gregorian calendar ಪ್ರಕಾರ while calculating the limitation, first day is to be excluded, last day is to be included. Date.
If it is calculated, my lord, rightly, my lord, office is, my lord, 60 days, my lord. If it is 61 days, my lord, I am out of that.
Yes.
But here, my lord, 60 days. That has to be considered for conversion of the.
In light of the appeal being filed filed with the limitation of 120 days.
Yes, ma'am.
Of 120 days. And as the period of delay does not exceed 120
Yes,
days.
yes.
IA 1 of 24 is allowed, delay is condoned.
Please.
Same order. 50% deposit.
Yes, ma'am. Say within 8
Competitive
weeks.
Withdraw.
8 weeks.
50% deposit within 8 weeks. Please.
Seal number 23, Ullaperu.
But the order, there is small correction has taken place. Number of the application. Page number 8.
Page number
8, fourth line. It should be 20797.
Which page of the order?
Order of the page number 5,
5.
para 6,
Yes.
fourth line.
Yes.
It should be 20797.
20.
Yes, 0 is missing.
That's all.
Next.
Ah.
Not order of copy of the order, not the page number 6, sixth line. Again, 0 is missing.
See how important 0 is. 20.
20797. It should be.
Then counsel for the.
In the preamble and other body, it has come correctly. Only these two.
Then counsel for the petitioner submits typographical error as crept in the order wherein at para 6 and 7 of the order, reference to application number 20797 of 2023 has been shown as 2797 of 2023. In light of the submission made, the number of the application found in the fourth line in para 6 and eighth line at para 7 to be read as application number T20797 of 2023 instead of 2797 of 2023. Office to take note of the same and the order passed on this day and the order passed on 29/2024 is to be read in terms of the modification made in today's order.
Great.
Number 24, Kedar Desai,
Notice. my lord.
Yes. Issue notice of file number 1 and appeal memo to the respondents.
They are insurer, yeah. No, no.
Response number 1 is matter.
So and so's direct. Okay. So and so's direct.
Wait, so do it the direct notice for respondent.
Yes, next.
number 35, Sanjay, Attorney.
Transfer sir.
The appellant is wife and divorce granted by the respondent husband on cruelty grounds. Cruelty ground,
Ex parte, no?
not ex parte, cruelty ground,
Contested.
contested.
Then you take out notice. Why did delay so long?
There is 193 days delay.
193 days delay. ಮದುವೆ ಮಾಡ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? So notice of file number 1 and appeal memo to the respondent. Notice.
Number 26, Amtesh Patil.
26 and 32, both are connected minutes. In the 26 minutes, the petitioner was elected as a president of the Gram Panchayat minutes in the year 2009 to 10 minutes. 2007, and he was there as a president up to 2010 minutes. And in the year 2007, my lords, there was a complaint was filed by the one Sharana Basava of the village man, alleging that there were some irregularities in the Gram Panchayat, and while executing the works of the Gram Panchayat, the engineer, my lords, and other employees, along with the president, they have indulged in malpractices. Then the Lokayukta, my lords, has appointed the committee on 29/3/2014, my lords, annexure, page number 16, my lords.
Now you have gone before the tribunal.
No, my lords, absolutely there is no notice served on me entire throughout the proceedings.
No, you're a government servant.
No, my lords, I am the president of the Gram Panchayat, ex-president of the Gram Panchayat.
You're challenging the order of the Lokayukta.
No, my lords, Lokayukta at page number, my lords, 41. Your lordship should see that since he comes under the provisions of Karnataka Gram Panchayat Act and he is not a civil servant, my lords. Therefore, the Lokayukta has directed for taking action as per the provisions of Panchayat Raj Act. Page number 41, paragraph 14. Sri Hanuman Gowda Timmapur. That is the person.
When is this order passed?
This order is passed on the year 2014.
Then what now? What?
No, my lords. Thereafter, the proceedings, we have absolutely not at all in the knowledge, my lords, these proceedings. No notice was issued. On 10/6/2015, my lords, there was an order annexure C, my lords, page number 42. 243A, my lords, is not attracted against the ex-president. Therefore, further directed to initiate proceedings under 246(8) of the Panchayat Raj Act. Then, my lords, in the year annexure D, page number 43, my lords, 19/6/2021. And they issued the notice under 246(8) for initiating the proceedings, my lords. And this notice, your lordship should find that at page number 45, annexure E, my lords, it is mentioned as Hampangowda Halapur, Linksgur, my lords. Taluk E belongs to the Manvi Taluk, old Manvi Taluk, now Maski Taluk. It comes under the now Maski Taluk.
Let us see, let the other side come.
But one request is now FLW is issued.
It's okay, let us. We can't, I'll reserve liberty, you move the vacation bench.
Must kindly see page number 50.
You move the vacation bench, only in the presence we can consider, let them verify it. The order is passed long back.
No, not about the order, my lords. Now the order is passed on 21, which is not in the knowledge of this petitioner. And subsequently, my lords, And this issue is covered by the division bench.
That
of
let
this
us say in their presence. Otherwise you serve the Lokayukta, let us let them.
one. I will serve, but kindly pass, sir. I will bring
Pass.
him. 32 could same matter.
32 same, pass.
Number still number remaining matter still number 27.
This matter, my lord.
My lord, it is also similar to, my lord, earlier disposed of contempt petitions. Lord, that is altogether 9,87,000 and odd amount been, my lord, agreed by both the, my lord, parties.
Correct, but some
Yes.
case must be filed.
Yes.
In the connected matter, no memo was filed. How we can pass same order?
That is, my lord, what happened in the memo, my lord, that is the, on the copy of it, that clear matter, my lord. In that, my lord, that amount is calculated to the, all the, my lord, which is worked, my lord. That amount along with the memo, my lord, that order is filed. So that memo is, that is sufficient to the, my lord, all the cases. But kindly see the order, my lord, passed by the deputy commissioner. That is regarding the interest. So all the, my lord, work which is done by the, my lord, complainant. Various, my lord, village, the various of the taluka, my lord, work.
So this is a common order.
Yes, my lord, that's why, my lord, I filed, that time, my lord, I made the mention, my lord. Memo, my lord, is filed, my lord, they taken maybe on record, my lord. This is also helpful to the others, my lord, content petition. Only, my lord, subject to filing undertaking, we have to file that amount. We taken the time, my lord, from 11/9, or that amount, that period is taken. So that amount will pay undertaking by filing the affidavit. In the first case, my lord, you will also be directed me within 3 days. We filed it, my lord, that is. So far as other cases concerned, my lord, 1 week I sought time. Only that correction is a requirement.
ಅದ್ ಮಾಡಿದ್ದೀರಾ?
Lord, may I make a submission?
Just hold,
Please.
Shall we pass an order like this?
Yes.
The second matter, just have it.
Yes, I have gone through.
ಅಲ್ಲಲ್ಲ ಇದು ಫ್ರೆಶ್ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಆಯ್ತು.
ನಾವಿನ್ನು ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ. You read from first, Mallikarjun.
Please. So and so, my lord, state that he has filed the memo dated CCC 2,213 of 2023 and submit that in the present case also, noticing that factual matrix is identical, the same stand may be taken note of. It is further submitted that in light of the same, the interest as admitted would be paid within 2 weeks from 11/9/2024. This is the, my lord, order passed in the so-and-so 2-1. The memo filed by the learner so-and-so as
Correct.
follows.
So then the last one you read.
In view of the stand of the government advocate and taking note of the order passed in so-and-so, the present proceedings are dropped.
Yes.
Same, my lord.
Still, sir.
Same.
Now in the.
It is made clear that they are undertaking to pay the interest within 2 months from 11/8/2023 to be filed within 1 week from today. Anta
ಅದಿಲ್ವಾ ಅದು?
Alilla.
ಇದ್ರಲ್ಲಿ. It is made. That I have said, no?
Yes, ma'am.
Undertaking to pay interest within 2 months from 11/9/2024
Filed.
and affidavit to be filed
Within 1 week, my lord.
within 1 week.
Please.
Now today's matter,
This is also same, my lord.
identical.
Same, my lord. That's why I filed the memo, my lord. This totally 5, my lord, taluks, my lord, when 5 writ petitions was filed. 5 contempt is filed.
Memo filed. ಇವತ್ತು matter memo filed. memo filed. ಆಮೇಲೆ ಸೇಮ್ ಆರ್ಡರ್ ಇದು ಇದೆಯಲ್ಲ ಇದು ಸೇಮ್ ಆರ್ಡರ್. ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ ಸೇಮ್ ಆರ್ಡರ್ ತೋರಿಸಿ. ಎಸ್
Please. watch.
Great.
Number 29, Ganesh Naik.
Appearing for the appellant.
Yes.
My lord, is the appellant, my lord, was appointed as the Anganwadi helper in the 15/11/2018 on base of the notification issued by the respondent number 1 for the vacancy post, my lord, is the Ainapur, my lord, is the Anganwadi helper post, my lord. Same, she was the appointed, my lord. On that day, my lord, she was the applied on the 9th standard. My lord, as per the 5th respondent and as well as the appellant, both are the widow. The widow category same to be considered, and my lord, the appellant is the eligible for the said post, and the appointment has the Anganwadi helper in the year of the.
So you take us to the writ petition cause title and you tell us.
Please, my lord.
You are the, who are you? You are the petitioner.
We are the, my lord, is the respondent number 5, my lord.
What
The writ
happened?
petition.
Your selection was set aside.
Please, my lord, there is
On,
same thing.
on what ground?
My lord, is the higher education is the considered as per the para number 5, my lord, there is.
So Irama had more marks than you.
Please, my lord.
That is the ground taken.
Please, my lord. No, my lord, he has the appellant is the higher qualification. He is the, my lord, as per the selection of that, my lord, is the Anganwadi
But
helper.
to the rank in the writ proceedings.
Please, my lord, we are the, my lord, is the petitioner.
Irama.
Irama is the petitioner in the writ petition.
Correct.
The
Now-
5th respondent, my lord, is the, my lord, is the appellant, is the Savitri Bai.
So it was set aside on what ground?
My lord, is the higher education, my lord. She was the completed as the SSLC. On that base, my lord, has the trial, my lord, learned single judge is the consider and set aside the order.
So now you have studied what?
My lord, is the SSLC, my lord. We are the applying for the 9th standard only, my lord.
Correct. So now this question we have to hear.
Oh.
You take no, let us see. State you
In
take.
this case, may I?
No, but there is some reference to order in writ petition.
Yes, madam.
Please,
In the,
106541 of
yes, madam.
2015.
In that writ petition, I am the petitioner before the, my lord, learned single judge. I relied on that judgment. The very same question.
One small
one
submission, my
minute,
lord.
The very same question which we involved in this case and that case covered. So the learned single judge has relied on that judgment and quashed the appointment. My lord, the question is very simple. This post is called for, my lord, Anganwadi assistant. As per the notification, minimum qualification is 4 standard, maximum is 9 standard only.
Where is that
Yes,
page?
that's. Your lordship may kindly see page number 26, my lord, annexure B. Annexure B, last, my lord, Kanishta, last, my lord, second paragraph.
ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ 4ನೇ ತರಗತಿ ತೇರ್ಗಡೆ.
Yes, my lord. ಕನಿಷ್ಠ 4ನೇ ತರಗತಿ ತೇರ್ಗಡೆ, ಗರಿಷ್ಠ 9ನೇ ತರಗತಿ ತೇರ್ಗಡೆ. ಇದರಲ್ಲಿ ವಿದ್ಯಾರ್ಹತೆಯುಳ್ಳ ಆಯ್ಕೆ ಮಾಡಬೇಕು. 9ನೇ ತರಗತಿ ಹೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಹತೆ ಆಯ್ಕೆ ಪರಿಗಣಿಸುವುದಿಲ್ಲ. The reason is.
That's the point.
Yes, madam. The reason is this, madam.
That's the notification.
Yes, madam.
There ends the matter.
Yes, madam. So my lord, she studied, my lord, 10th. But however, while filing an application, she mentioned that I studied only up to 9th. So I filed an objection, my lord, before the, when provisional list was issued, I filed an objection specifically containing that she passed at 10th. What the reason the authority is given, that I have produced the authority reasons
Number
also.
61, my lord.
That page number, my lord, 61. Your lordship may kindly see Ainapur first paragraph, first day. Since the respondent herein has produced the marks card of 9th only, hence we have selecting. In spite of I have produced the 10th marks card in the statement objection that she studied the 10th. The whoever qualified for the 10th, my lord, she will be eligible for the post of, my lord, Anganwadi worker, not Anganwadi assistant.
Are the applying for the only for the 9th standard man?
And my lord,
We are the not the used for the SSLC marks card man.
no, no, he,
We are the not used as per the SSLC
Not
marks card.
required, but you can, if you are.
Only the apply for the 9th standard only.
You can't do that.
yes,
Already has per the my lord, the objection is the same to be considered by the authority.
no.
The page number 61, my lord.
Forget it.
Page number 61, my lord.
You go to the notification.
Please, my lord.
If you are above 9th, you are disqualified.
So, my lord, is the 9th above 9th is the disqualified, my lord. But
yes.
we are the applied for the 9th standard, my lord. We are the education for the 10th standard. The 10th standard is the not barred, my lord.
Barred.
Barred, my lord.
No, my lord, we are the on that base we are the not considered by the authority. My lord, kindly the objection was the page number 61.
No, what we are saying,
Please.
what does the notification say?
Notification is the minimum qualification is the 4th standard.
What is the maximum qualification?
Is the 9th standard, my lord.
You are above 9th.
Ninth.
My lord, we are the applying for the 9th standard.
ನೀವೇನಾದ್ರೂ
ಅಲ್ಲ ನಾವು ಅಪ್ಲೈ ಮಾಡಿರೋದು 9th standard.
not relevant.
No, my lord, has the
Can't.
my lord, has per the authority also has the same to be clarified and my lord, the same the objection is rejected, my lord.
The notification is clear.
My lord, the page
So
number
the-
61, my lord. Kindly page number 61,
60,
my lord, 61, my lord. The same the authority has the same to be consider it, my lord. ಅದನ್ನೇ consider ಮಾಡಿದ್ದಾರೆ. The Ainapur one, page number 61, my lord. Srimati Savitri Bai Ganda so and so, my lord, is the key appellant. The Srimati Irama Ganda Mallappa is the my lord, the 5th respondent. My lord, ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆಯಾದವರು 10ನೇ ತರಗತಿಯಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗಿದ್ದು
ಮೇಲಿದೆ ಸಮಯ.
ಮೇಲ್ಗಡೆ my lord, the top of the my lord, the top line. Page number 61.
Yeah.
ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆಯಾದವರು 10ನೇ ತರಗತಿಯಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗಿದ್ದು ಅವರ ಆಯ್ಕೆಯನ್ನು ಕೈಬಿಟ್ಟು ತಮಗೆ ಆಯ್ಕೆ ಮಾಡಬೇಕೆಂದು ಆಕ್ಷೇಪಣೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
Lord,
ಹತ್ತನೇ ತರಗತಿಯಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗಿದ್ದು ಅವರ ಆಯ್ಕೆಯನ್ನು
Please, my lord, the page number 61 top line.
ಇದೆ ಇದೆ.
My lord, is the authority is the same to be answered it, my lord. ತಾತ್ಕಾಲಿಕವಾಗಿ ಆಯ್ಕೆಯಾದ ಅಭ್ಯರ್ಥಿಯು ಆನ್ಲೈನ್ ನಲ್ಲಿ 9ನೇ ತರಗತಿ ಅಂಕಪಟ್ಟಿಯನ್ನು ಲಗಿಸಿರುವುದರಿಂದ ಆಕ್ಷೇಪಣೆಯನ್ನು ಕೈಬಿಟ್ಟು ಸದರಿಯ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸಲಾಗಿದೆ.
This is what they give a reason.
Finality.
This is wrong. Wrong reason.
My lord has per the clear, even though my lord has the guidelines, he has the not to clear that my lord has the higher education only my lord added for the my lord is the bonus point my lord is the consider.
No, when it says, now see, I'll just tell you. Now we'll say orderly who applies to the court must be 10th pass. That minimum, that's a different.
Please, man.
Where maximum is stipulated.
Please, man.
You can't go beyond that.
ಅದರಲ್ಲಿ my lord is the higher education ಅನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ದಾರೆ. But he has the consider ತಗೋಬಾರ್ದು ಅಂತ ಬರೆದಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಅಷ್ಟೇ ಅದನ್ನ. My lord, I read it, my lord, there is. At least, my lord, is the case. Government can be at least they clarified that, my lord, as per the guidelines, my lord.
Now we can't intervene in this. He is eligible. You also may be eligible. He is eligible in terms of notification. There ends the matter. There's no point. We cannot go beyond the
My
notification.
lord, as per the we are the appointing in the year of the 2018, my lord.
Can't
Since
help
the
it.
6 years we are the working, no, my lord. We are the widow, my lord. Already, my lord, the 3 children are on the depend on that, my lord, is the earning of that, my lord, Anganwadi helper to education, my lord. There is the key already 6 years, my lord, has the key, no, my lord, has the key working, no, my
The
lord.
writ petition was filed with within how many months?
My lord, is the after the key
No.
6 months, my lord, there is the.
No. Kindly see the order is passed on 16/10/2018.
The 15/11/2018, my lord.
Writ
Is the
petition is
writ
filed,
petition filed is the 10/1/2019, my lord.
within 2 months.
Months, huh?
Yes.
3 months.
We can't help it.
Lord, at least, my lord, as the key, government can be clarified that, my lord, as the key, the specific word, my lord, the higher education cannot be a word, my lord.
That's up to the government.
rules ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಇಂಟರ್ಪ್ರಿಟ್ ದಿ ನೋಟಿಫಿಕೇಶನ್
ಅಲ್ಲ ಅದರಲ್ಲಿ ಹೈಯರ್ ಎಜುಕೇಶನ್ ಕಲಿಲೇಬಾರ್ದು ಅಂತಂದ ದಟ್ ಈಸ್ ದಿ ಡಿಫಿಕಲ್ಟಿ my lord. There is
ಅಲ್ಲ
the ninth.
ಇಂಜಿನಿಯರ್ ಆಗಿ
ಹೌದು.
ನಾವು ಮನೆಯಲ್ಲಿ ಕಸ ಗುಡ್ಸೋ ಕೆಲಸ ಅಪ್ಲೈ
My lord,
ಮಾಡಿ
is the key unemployed ಇದ್ದಾಗ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ sir.
ಅದು ಏನ್ ಮಾಡಿಲ್ಲ ಹಂಗಲ್ಲ. We mustn't say, we leave it at that. It's live proceedings.
Sorry, my lord.
No, not sorry, we are sorry, we cannot say, we were. So that's the rule, that's the rule.
At least, my lord, is the key, government to be clarified that, my lord, as the rules, my lord, is the key, bar the key, my lord, the higher qualification.
We'll ask them to make more employment opportunity.
there is the question that my lord has the same to be object by the my lord the fifth
The-
respondent before the authority.
Present writ petition, writ appeal is filed by the respondent number 5 in the writ proceedings, challenging the order of the learned single judge dated 5th August 2024 in WP 200156 of 2019. The parties are referred to by the rank before the learned single judge for the purpose of convenience. Iramma, the petitioner, had filed the writ petition challenging the appointment of the fifth respondent,
Yes.
Savitra Bai. Insofar as it was stated that the selected candidate, Savitra Bai, was ineligible as she had passed 10th standard, while the maximum qualification permissible to make the applicant eligible to apply to the post was 9th standard pass. Full stop. The petitioner had also challenged the office order overruling the objection of the petitioner insofar as the select list. Full stop. The writ petition came to be disposed of, wherein the learned single judge has taken note of the order passed in writ petition 106541 of 2015, dated 3/1/2024, wherein the learned single judge had observed that a candidate who had completed SSLC would not be entitled.
Yes.
Full stop. It was held in the said writ petition that a candidate who has qualification in excess of the stipulation cannot be considered in the selection process. Full stop. The said order has been challenged on the ground that the restriction imposed is in the notification is unreasonable. Full stop. The notification at annexure B at point number 1, Roman 2, reads as follows. Full stop. It is clear that the minimum qualification is 4th standard pass and the maximum qualification is pass in 9th standard. Full stop. It is further clarified that any person having qualification in excess of 9th standard would not be considered for selection. Full stop. Peruse the writ petition, Ria. What is annexure R? Adರಲ್ಲಿ?
Are you my lord is the key
Selection
report-
list.
Selection list, my lord.
Selection.
The prayer is for setting aside the selection list at annexure R. Clearly, in light of the stipulation in the notification, and as it is not in dispute that the fifth respondent had passed her 10th standard, she was ineligible in terms of the condition imposed. Stop. Accordingly, we find no reason to interfere with the reasoning of the single judge who has observed that a person who has excess qualification was ineligible. Such reasoning is in consonance with the notification at annexure B and the stipulation which clearly makes ineligible those with the qualification in excess of 9th standard. In light of the respondent number 5 having passed SSLC, she is ineligible, and accordingly the order of the learned single judge is upheld. Writ appeal is dismissed.
Number 30, Amir Abdul Qadir Gunnapur.
I'm appearing for the caveator.
We'll have it after reopening day.
Anyhow, my lord, they don't have a case, my lord. It's a case of premature transfer. The matter is squarely covered, my lord, in my application before the KAT of the, my lord, the division bench, my lord, of the learned Chief Justice, my lord, wherein, my lord, the transfer and the new transfer guidelines, my lord, they equated with the old, my lord, transfer guidelines, my lord, and held, my lord, that is, my lord, amenable, my lord, for judicial, my lord, scrutiny.
Shall we have it on the reopening day?
Please.
Reopening day, reopening day.
Sir, 3 days other sir, now senior sir.
Pass over.
Pass over.
Next.
Please.
Number 31, Kulaperu.
Lord, to appear for the petitioner, Lord. The petitioner has been issued with a notice to appear before the inquiry committee. Agreed by that, my lord, he has approached KAT, KSAT without looking into the material placed on record. Proceeded to pass the application, dismissing the application. Apart from that, imposing a fine of rupees 5,000. My lord will peruse annexure A2. I request my lord to peruse annexure A2, followed by A3, page number 19. 19 of my writ petition. ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ನೌಕರರ ವಿರುದ್ಧದ ಅನಾಮಧೇಯ ದೂರುಗಳ ಬಗ್ಗೆ ಕ್ರಮ. ಸುತ್ತಲೇ ಸೋಣ್ಸೋ. ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಸ್ವೀಕೃತವಾಗುವ ಅನಾಮಧೇಯ ದೂರುಗಳ ಬಗ್ಗೆ ಕೈಗೊಳ್ಳಬೇಕಾದ ಕ್ರಮಗಳ ಬಗ್ಗೆ ಉಲ್ಲೇಖಿತ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಕೆಲವು ಸೂಚನೆಗಳನ್ನು ನೀಡಲಾಗಿದೆ. ಇಂತಹ ದೂರುಗಳು ಕೆಲವು ಸಂದರ್ಭಗಳಲ್ಲಿ ವೈಯಕ್ತಿಕ ದ್ವೇಷ, ಅಸೂಯೆ ಅಥವಾ ಪೂರ್ವಗ್ರಹ ಪೀಡಿತವಾಗಿರುತ್ತವೆ. ಅಲ್ಲದೆ ದೂರುಗಳಿಗೆ ಪೂರಕವಾದ ಮಾಹಿತಿ ದಾಖಲೆಗಳನ್ನು ಸಾಮಾನ್ಯವಾಗಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಇಂತಹ ದೂರುಗಳಿಂದಾಗಿ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ನೌಕರರ ದೈನಂದಿನ ಕೆಲಸ ಕಾರ್ಯಗಳಲ್ಲಿ ಹಸ್ತಕ್ಷೇಪ ಉಂಟಾಗುವುದಲ್ಲದೆ ದಕ್ಷ ಹಾಗೂ ಪ್ರಾಮಾಣಿಕ ನೌಕರರ ವಿಶ್ವಾಸಾರ್ಹತೆಗೆ ಧಕ್ಕೆ ಉಂಟಾಗುತ್ತದೆ ಹಾಗೂ ಅವರು ಮುಕ್ತ ಮತ್ತು ನಿರ್ಭೀತರಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸಲು ಸಾಧ್ಯವಾಗುತ್ತಿಲ್ಲ. ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರು ದಿನಾಂಕ 4/8/19 ಟಿಪ್ಪಣಿಯಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರರ ಸಂಘವು ಈ ಸಂಬಂಧ ನೀಡಿರುವ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಿ ಕೇಂದ್ರ ಸರ್ಕಾರದ ಮಾದರಿಯಂತೆಯೇ ರಾಜ್ಯದಲ್ಲಿ ಸರ್ಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಅನಾಮಧೇಯ ದೂರು ಪತ್ರಗಳ ಆಧಾರದ ಮೇಲೆ ತನಿಖೆಗೆ ಒಳಪಡಿಸದೆ ಪೂರ್ಣ ವಿಳಾಸ ಸಹಿತವಿರುವ ದೂರುಗಳನ್ನು ಮಾತ್ರ ತನಿಖೆಗೆ ಪರಿಗಣಿಸಲು ಆದೇಶ ಹೊರಡಿಸುವಂತೆ ಸೂಚಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಾಣಿಸಿದ ಅಂಶಗಳ ಹಾಗೂ ಭಾರತ ಸರ್ಕಾರದ ಉಲ್ಲೇಖ 2ರ ಅಧಿಕೃತ ಜ್ಞಾಪದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಸ್ವೀಕೃತವಾಗುವ
Yes, now what happened?
Now, my lord, my application has been dismissed, saying that my rights are not affected and it is premature. And the authority who is inquiring is of my equal rank. He is of my, my lord, cadre. I have taken that ground also. Apart from that,
No, just one.
rightly, wrongly, my application is dismissed. No matter.
No, what are the, you filed a complaint against somebody.
Someone has lodged a complaint
It's-
against me, against me.
Now that has been entertained.
Without looking into the, my lord, contents of the complaint, without establishing, without satisfying. I have been issued with the notice to appear before the authority.
It's an anonymous complaint.
Lord.
It's an anonymous complaint.
Yes, anonymous.
Let us have a look at it.
Lord.
You have a copy of the complaint.
Yes, no, they have filed. Authorities have filed.
Page?
R1, my lord. My lord will find annexure R1.
The
Respondents have filed their statement of objection. My lord will peruse page number 31.
the name is there, Naeema Chowdhury.
ಅವರು ಶ್ರೀಮತಿ ಅಂತ ಬರೀತಾರೆ. Actually, he's a male, my lord. He's a male. My lord will find the correct name in the down.
Naeema Chowdhury.
Naeem Chowdhury.
Huh.
Naeem Chowdhury.
So, but why are you saying that this circular covers it?
A circular, my lord, even if there are addresses, particulars, they should not be, my lord, gone into. It is only with a view to discourage the government servants working in the department, not releasing their progress, complaints are required. And even if complaints are there, they should go into the contents, satisfy, only then issue notice. Have been issued notice just by seeing the complaint. And KIT, my lord, unfortunately, dismissing application, no matter. I'm not on that. 5,000 fine is imposed. My lord, I request my lord to peruse the order of the KIT. Annexure B. My lord, operative portion at page number 45. May I read, my lord? Page number 45.
Yes.
Order. The application is dismissed. The applicant is imposed a fine of rupees 5,000 for abuse of process of law, and he is directed to credit the fine amount of rupees 5,000 into the account of Chief Minister Relief Fund within a period of 2 months. Registry is direct and followed by, my lord, the direction issued to the registry to follow up.
No, correct. For the time being, you will be satisfied if the fine is stayed.
My lord.
Right now, you are saying let the fine be stayed and then we'll see later. Right of the contention advanced regarding imposition of fine. Imposition of fine is referred to in Roman point 2 of the order of rupees 5,000 is stayed for the present. AGA accepts notice for respondents. Only the state, isn't it? 5.
Annexure, A5, my lord.
No.
Annexure A5 issued by the principal.
No, just one.
Respondent number 5.
First title Nodi. Gopal Krishna.
Yes, my lord. Respondent number 5.
Alla.
ಅವ್ರು ಯಾರೇ ನೋಟಿಸ್ ತಗೋತಾರೆ ಅಂತ. To whom the AGA wants to take notice.
Personally, it has to go principal, my lord.
Huh?
Personally, it is.
So only 1 and 2 you will take.
Yes, ma'am.
1, 2, 3 no ilva.
3 also, my lord. No, all 1 to 5.
No,
My lord, state respondents.
they have some separate council. In Bangalore, they have a different council. 1 and 2, let him take.
Yes,
Then
sir.
we'll
1 and 2. 3 and
AGA
4, 5.
accepts notice for respondent 1 and 2.
Directorate of Diet.
Notice for respondents 3, 4 and 5. Petitioners permitted to serve counsel for respondents 3 to 5 appeared before the KT.
Interim stay of.
Stay of insofar as cost.
Next.
Yes.
Annexure A5 and, my lord, annexure B.
No, we have stayed insofar as cost. The remaining will keep it open. On their appearance, we'll see. Interim prayer insofar as other portion of the order is kept open to be considered upon notice.
Great.
Yes.
Great.
Last time. 32. ಮುಗಿತಾ? ಆಯ್ತಾ? ಆಯ್ತು ಪಾಠ.
Further reading matter, Silam 42, Vishal Pratap Singh. Forty-three. Ganesh Subhash Chandra Kalaburagi.
Yeah, 43.
These are externment matters which have been referred.
No, he has to submit, isn't it?
He has
Pass
made,
over.
he has made his submission on the last occasion. I was supposed to file, he had to give authorities.
Now let him come.
Yes.
Pass over. Next.
Silam 44, Lakshmikant G. Vijay Kumar sir.
Respondent.
AG sir, Vijay Kumar sir.
Yes, Vijay Kumar.
ಸರ್ ಮ್ಯೂಟ್ ಇದೆ ಸರ್, ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಮ್ಯೂಟ್ ಇದೆ ತಮ್ಮದು. ವಿಜಯ್ ಕುಮಾರ್ ಸರ್, ಏಜ್ ಸರ್? ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸರ್.
ಸ್ವಲ್ಪ ದೊಡ್ಡದು ಮಾಡೋದು, ದೊಡ್ಡದು ಮಾಡೋದು.
Yes, Vijay Kumar.
Yes. We can't hear you. We can't hear you. Full mad, volume full mad. Volume full mad. Yes. No, you are not audible.
ಸರ್ ರೀಲಾಗಿನ್ ಆಗ್ಬಿಡಿಬೇಕಾರೆ.
Just relogin otherwise.
No.
No, relogin.
ತಾವು ವಾಯ್ಸ್ ಕೇಳ್ತೀರಿ ಸರ್, ರೀಲಾಗಿನ್ ಆಗಿದ್ರೆ
Off ಮಾಡಿ ಆನ್ ಮಾಡಿ.
ಎಲ್ಲಿ ಕಳಿಸ್ತಾರ ಅದು?
My lords,
Yes,
am I audible, my lords?
yes, yes, you're audible.
Much obliged. My lords, on the last occasion, my lords had permitted me to make my submissions on the explanation to section 2 of the Karnataka Gunda Act, my lord. The explanation, my lords, where it reads, for the purpose of this clause, public order shall be deemed to have been affected adversely or shall be deemed likely to be affected adversely inter alia if any of the activities of the persons referred to in this clause directly or indirectly is causing or is calculated to cause any harm, danger, or alarm or feeling of insecurity among the general public or any section thereof or a grave or widespread danger to life or public health. My lord, in that regard, my lord, I had also placed before my lords a judgment, 9-judge bench judgment of the Honorable Supreme Court, the Constitution bench judgment, wherein a similar provision in the Coffee Post Act was upheld, my lords, where the deeming clause was upheld. And I had also placed, submitted before my lords the ratio of judgment in Buvalka Steels, where it was clearly stated how legal fiction or a deeming clause has to be given effect to while reading any statutory provision. Because deeming clause itself, is my humble submission is, my lord, it's an interpretive tool which would help the honorable court to come to a conclusion as to what could be the intention of the legislature and thereby give effect to such intention, my lord, in letter and spirit. Please. My submission further, my lords, would be, my lords, before I commence, I'd like to place before my lords a 3-page judgment of Muhammad Salim Khan versus CC both. In the last occasion, I could not place this. It's a judgment of their lordships, Justice Shilat and Justice H.R. Khanna, my lords. As my lords are aware, Justice Shilat and Justice Khanna were part of the bench in the Keshavananda Bharati judgment where they upheld they pushed the fundamental rights of citizens to the Hallett portals, and they gave it primacy over all else in the Constitution. And they said the constitutional amendment, the power of the constituent power of the Parliament is limited to such an extent that they cannot amend the basic structure, and which includes the fundamental rights, my lords. It is these two individuals, my lords, who have placed this judgment, who have delivered this judgment. My lords, have it, my lords?
Yes.
Please, my lords. My lords, this judgment pertains to a person who was accused of throwing bombs and lighting up fire to some public property like a bus, my lords. My lords, that is available in para 4, the grounds of detention. In the grounds of detention. I would not like to take more time, my lords. Those grounds are there, my lords, in which they have said the petitioner, along with his associates, one Dule Day and another person, committed mischief by setting fire to a double-decker state bus at Chetla Central Road and threw bombs aiming them at the said bus, causing thereby damage to the said bus and also panic and disorder in that area. And there is another accusation, my lords. Next page, my lords, may draw, my lords, candidate to para 9, my lords. Because of paucity of time, my lords, I am constrained to rush through the precedent. Para 9, it discloses that the accused was discharged of the offences. The said offences he was discharged, and after that, the impugned order of detention was passed. This is what the Honorable Court had to say, my lords. Para 9. Since the petitioner was arrested on May 26, 1971 in connection with the criminal proceedings taken against him in relation to the very incidents which were also subject matter of on which the impugned detention order was passed, and there was some doubt as to whether he was in jail in connection with those proceedings on the day when the impugned order was passed, or that is on June 18, 1971. We asked the state government to furnish us further particulars as both as regards to the said criminal proceedings and his whereabouts on 18 June 71. The further particulars furnished by the government show that the petitioner was arrested on May 26, 1971 in connection with the said incidents and was produced the next day before the magistrate Alipur. The petitioner remained in jail, therefore, as an under trial prisoner until June 14, 1971, when the magistrate granted him bail and released him from custody. On 18 June 1970, the magistrate discharged the petitioner of the charges against him, presumably on the ground that there was not adequate or satisfactory evidence against him. Thus, the petitioner was at large on June 18, 1971, when the impugned order detaining him was passed by the district magistrate. Here, my lords, the mere fact, however, that criminal proceedings in connection with the same incidents had been adopted against the petitioner and he had been discharged by the trying magistrate does not mean that no valid order of detention could be passed against him in connection with those very incidents, or that such an order can, for that reason, be characterized as mala fide. It might well be that a magistrate trying a particular case under the Code of Civil Procedure has insufficient evidence before him and therefore has to discharge such a person. But the detaining authorities might well feel that though there was not sufficient evidence admissible under the Evidence Act for a conviction, the activities of that person which they had been watching were of such a nature as to justify an order of detention. From the mere fact, therefore, that the magistrate discharged the petitioner from the criminal case lodged against him, it cannot be said that the impugned order was incompetent, nor can it be inferred that it was without a basis or mala fide. That the Honorable Court places reliance upon another larger bench judgment, which is Sahib Singh Duggal, my lords. Because there is a reiteration of that in this judgment, I will not go into that judgment. My humble submission is this with regard to this judgment, my lords. The Honorable Court, my lords, in this particular case, was very much seasoned of the fact that there was an order of discharge passed against the detainee in another case, and that the facts and the reason for passing the detention was the basis of which was in a case which he was already released and was discharged. Despite that, court comes to the conclusion that the evidence which is required to ensure conviction of a person in a regular criminal trial and the assessment which an authority makes, an executive authority makes for the purposes of detaining a person under preventive detention are two different standards altogether. They are not comparable. It is very well possible that a person sustaining or obtaining a conviction may be different for the law enforcement authorities. But if there is sufficient material and in their subjective satisfaction, it is sufficient or it is necessary to detain a person to ensure that he does not cause further mischief to public safety or public order, then, my lords, an order can be passed. That is the purport. And the reason why I placed before this particular judgment before, my lords, though there are many, is because the judges, my lords, the two judges, Justice J.M. Sheelath and Justice H.R. Khanna, both go on to later write the Kesavan and the Bharat judgment, two separate concurring judgments, where they've given primacy to fundamental rights over the constitutional power, the constituent powers, Parliament's constituent power to amend the Constitution, one. And later, after that, in ADM Jabalpur, as my lords may recall, His Lordship Justice Khanna was the sole dissenting judgment in that judgment, where the rest of the bench, in the Constitutional bench, said that in times of emergency, even the right to life and personal liberty is suspended. My lord, it is the character of such, it is a judge of such caliber who comes to the conclusion that in cases like this, judges who believes in fundamental rights of the citizens is of paramount importance. He also comes to a conclusion that in cases like this, some cases like this, it is necessary to remove such people from outside, from society, so that the social fabric of this nation is not damaged. And they have to be kept outside so that they cannot further cause any mischief to public order or become danger to fellow citizens, because they exercise their freedoms in a manner that their liberties, personal liberties and life and limbs of other citizens are endangered. So that is the reason why, my lords, this particular judgment I have placed before my lords. Further, my lords, I'd like to draw my lord's kind attention to the live link argument apparently that is raised by the petitioner, my lords. The live link argument may draw my lord's kind attention to, my lords, I've placed 3 judgments in that connection in volume 3 of my list of authorities. I'll read out from only one judgment. Volume 3 from the list of authorities.
This type, small one.
Yes. Money last.
ಅಷ್ಟೇ.
Yes.
Please, my lord, para 8, my lords. Page 366. The running page number 366, the judgment commences, my lords.
Please, madam, we lost.
Yes.
Page 366, my lords. May I draw my lords' kind attention to page number 369. The relevant portion is in para 8, the reason for his detention. The order of detention shows, my lords,
Just
that
one minute.
para 8.
Just one minute.
Please, I'm
Just
sorry.
one minute.
I'm sorry.
Page.
Page 369, my lords.
Yes.
Please, I'll read from para 6 itself, my lords. In support of the appeal, the learned counsel for the appellant submitted that there was no libeling. Reference was made to some of the incidents which allegedly took place in 2005, and in any event, when preventive action in terms of section 107 of the CRPC and section 110 of the CRPC have been taken, there was no need for passing the order of detention. It was also pointed out that the alleged facts and the alleged acts at the most related to law and order situation, having nothing to do with the public order. It was further submitted that the statement of in-camera witnesses should not have been relied upon by the detaining authority without forming an opinion as to whether they represented the truth. Learned counsel for the respondent state and its functionaries, on the other hand, supported the order of detention. The order of detention shows that the appellant is often hired on payment by antisocial elements for commission of violent crimes. The detainee and his associates always possessed deadly weapons, and the instances highlighted related to 1/5/2005, 1/6/2005, and 2/4/2006, and a dispute between the particular committee and the builders over the possession of land and the activities of the detainee. And lastly, on 24/3/2007, it has been noted that the serious riotous situation developed at a particular high school ground where hundreds of members of a particular community had assembled. It resulted in intense fear and panic situation because of the activities of the detainee. It was also pointed out in the order of detention that the various preventive action taken under 107, 107 yielded no positive result, and the detainee continued his violent and criminal activities. Reference was also made to the witnesses who examined in camera. So far as the truthfulness of the witnesses are concerned, reference was made to section 8(2) of the Act, which permits withholding the statement of the certain witnesses in public interest. Para 9, my lords. There are passages culled out from Ram Manohar Loya's judgment, which my learned friend has already read. I would like to draw my lord's kind attention to the last para of that judgment, my lord, which has been extracted. It's on page 372.
Yes.
It's a small number. The numeral is in small font, my lords. Number 13.
Yes.
Please, my lords. There, that is the conclusion of Ram Manohar Loya's judgment, my lords. The next paragraph is what I'd like to draw my lord's kind attention to. Para 10. Coming to the question of libeling, it is to be noted that the provision empowering detention relates to habitual activities of the proposed detainee. Therefore, there has to be an instance which may not be of immediate proximity, but may indicate that pattern. In the instant case, the incidents cannot be said to be of remote past to warrant conclusion of the absence of libeling. May I read it again, my lord, with my lord's kind permission for my benefit?
Yes.
Please. Coming to the question of libeling, it is to be noted that the provision empowering the detention relates to habitual activities of the proposed detainee. So, my lords, the court makes this very clear. The question of libeling is associated with the conduct of the detainee.
So you're
It is
saying
not
it may
relating to any timeline.
It may not be in
Libeling
the.
is not related to any timeline. It is related to conduct. Therefore, there has to be an instance which may not be of immediate proximity. So the last incident may not be of immediate proximity, which would warrant detention, preventive detention, but may indicate that pattern. So if there is an instance or an incident which can indicate a pattern, like in this case, my lords, where this particular petitioner is accused of all heinous offenses all kinds of offences under all chapters which are required under the Gundas Act. From heinous to the most barbaric of offences, where he is been tried for an offence of removing nails of one of the kidnappees and who was killed later. So, my lord, and further, my lords, the accused was also, the detainee was also accused, and in case relating to Karnataka Control of Organized Crime and Criminal Activities Act. My lord, may I draw my lord's kind attention to the detention order, my lords. I'll just point out two sentences. The English translation of that detention order, my lord. I will not read from the, I'll read only a few sentences in that.
Page?
Page, my lord, the page 35 of the writ petition, my lord.
Yes.
The serial number 20. Serial number 20. Crime number
Yes.
46 of 2017. Under sections 143, 147, 148, 341, 326, 109, 120B, 393, 307, 201, 212, read with section 149 IPC, read with section 2, capital D, E, F, and 31, 32, 32, 33, 34, 35 of Karnataka Control of Organized Crime and Criminal Activities Act and registered in Chowk Police Station, Kalaburagi. The complaint was raised on 23/3/2017 at 2:30 hours by Ramesh and hotelier. And my lords, basically the next page, my lords, the last next page. On the basis of this complaint, charge sheet is submitted against 13 persons, including you, in Sessions Court, Kalaburagi, SC number 1 of 2017, Kekoka. The case is pending for trial. The next date of hearing is on 4/6/2024. So he's been coming to Gulbarga. It's not that he has not been coming, my lords. May I draw my lords' kind attention to the next page, my lords? Page number 38. On the top, my lords, on the basis of the complaint, my lord, the first para reads of the first para concludes what has been said in the crime number earlier, my lords. Next, my lords, my lords have this, my lords, in addition to the above cases.
Yes.
Following CRPC cases are registered against you. Do my lords have it, my lords?
Yes.
Please, my lords. Serial number 1, Chowk Police Station. Date of report 11/2/2023. In case number in section number 12 of 2023 under section 107 of CRPC dated 15/3/2023, numbered so and so, bonded over. My lords may kindly mark that.
Yes.
He has executed the bonds, undertaking to maintain peace.
Yes.
Next one, my lords. Same police station. Crime number this time is number 22 of 2024. Under the same provision, section 107 of CRPC. Here also is bonded over. Here also is executed. As my lords are aware, my lords, a detention order I can execute it anywhere in the country. I can take a detention order, travel to Hyderabad, Delhi, wherever he is, and serve it on him, and then take him into custody. But 107 proceedings is done only in my jurisdiction, in the local police station's jurisdiction. 107 proceedings is incapable of delivery elsewhere, the order under 107. So is very much in Gulbarga. Even as in 2024, 17/3/2024, my order is dated, my lords. My order is dated 29/5/2024. Not even 1.5 months. Where is the snapping of live link, my lords? I ask myself this question. Factually, what has been stated in the writ petition is incorrect. He still carrying on his nefarious activities in my town. I warn him, I call him to my police station, ask him to execute a bond. He does. Continues, I again call him. He continues with his nefarious activities. So I passed an order of detention. The detainee, as my lords are aware, my lords, he is operating as a kingpin, responsible for extortion. He is accused of selling arms, not a small open, not any, my lords. Not that he stole some car tire and ran away. It's not like that.
Yes.
Here is an offender who is capable of causing disturbance to peace. Here is a person who is capable of disturbing public order. So, my lords, my humble submission is, this preventive detention was warranted and it was rightly done so under the circumstances. Further, may I draw my lord's kind attention to the arguments, my lords, the case law, the two case law, I think primarily the petitioners have placed reliance upon. One is Amina Begum and another one is Jashila Shaji.
Yes.
My lords, before I go to their authorities, my lords, I'd like to draw my lord's kind attention to Khudiram Bose itself, which was the first case that I placed reliance upon, which has been referred to in one of the cases which the petitioners have placed reliance upon. My lord, this is a case.
Yes.
My lord, this is a case where the Honorable Court, a four-judge bench of the Honorable Supreme Court, was asked to look into the sufficiency of the material to pass an order, and also to see if non-furnishing of material particulars would vitiate the order of detention. In this case, my lords, the Honorable Supreme Court clearly in paras 2, 3, 5 to 18, my lords, I have submitted a list of authorities with the relevant para numbers, my lords. Have I been able to place it before, my lords? My lord? A two-page list of authorities with page numbers I have furnished, my lords.
Mallikarjun. On the 8th page, note ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ.
Other side give.
Paragraph number.
Other side.
ಅಲ್ಲ, ನೀವು
ಕೊಟ್ಟದ್ದು, ನೀವು ಕೊಟ್ಟದ್ದು.
2 page with paragraph number.
Please, my lords, I will furnish it by during the lunch hour, my lords. Please.
Yes, yes.
Furnish another. My humble submission is, my lords, that judgment, my lords, and the judgment which follows that Ummu Salima.
Yes.
My lords, all these judgments demonstrate clearly that what material the detaining authority places reliance upon, it is only that particular material which has to be furnished to the detainee, 1. 2, and with regard to illegible copies which they have made allegation about. Illegible copies is one PF list, my lords. That was not placed reliance upon by me to pass the detention order. So that is irrelevant. That is what the Honorable Supreme Court has said in various judgments, including Radhakrishnan and this one, my lords, Abdul Hakim's case. My lords, further, the learned friends also apparently with regard to delay. Delay, my lords, has been clearly explained in Ummu Salima's case, where even there is a person, the authority which was supposed to confirm or reject the detention order was not in the country. He was not available for more than 10 days. He comes back and passes order. Court says there is no unreasonable delay. It cannot be a pedantic or a mechanical adherence to some standards. Procedure also means that there has to be some amount of elbow, fair play in the joints. If a representation is made, it needs to be communicated to the particular authority. The authority has to call for records, then pass orders. So that has been done within time. So there is no question of delay in this, my lords. Per incurium, as I've already submitted, my lords, a live link refers to not the last incident. It is with regard to the pattern. And per incurium, my lords, I'd like to draw my lords' kind attention to my volume 2, my lords. Volume 2. 3 cases I've placed reliance upon. Why I say the judgments which my learned friend has placed reliance upon, the last 2 judgments, Amina Begum and Shaji Sheila, Jai Sheila Shaji, their per incurium, to the extent that they have misconstrued the judgment in the Khudiram Bose's case. Khudiram Bose clearly, categorically says no, it is not necessary to give all the material. What is relied upon, only that needs to be furnished. These 2 cases they place reliance upon to say that there has to be some mechanical adherence If there are only 2 pages that I have placed reliance upon, 10 volumes have to be furnished. And if in one of them there is no pagination is wrong, if the photocopy is not legible, then the order has to go. My lords, my humble submission is that, my lords, that goes against the very grain, the very ratio laid down by Khudiram Bose's case. And if there is any case subsequently which has been passed contrary to the ratio laid down Khudiram Bose, that particular judgment, my lord, would suffer from the vice of being per incurium. And list of authorities, volume 2, my lords, page 274. 274 is the judgment of Municipal Corporation of Delhi versus Gurnam Kaur. Para 11 is the relevant paragraph in this, my lords. Lord, and just the substance of the judgment is, my lords, that the only thing in a judge's decision which is binding or which becomes a binding authority is a principle which has been decided. And decided under what condition, under what terms? Para 11. Pronouncements of law. May my lords have it, my lords?
Yes.
Pronouncements of law which are not part of the ratio decidendi are classed as obiter dicta and are not authoritative. With all respect to the learned judge who passed the order in Jamnada's case and to the learned judge who agreed with him, we cannot concede that this court is not bound to follow it. It was delivered without argument, without reference to the relevant provisions of the Act, conferring express power on the municipal corporation to direct removal of encroachments from any public place like pavements or public streets and without any citation of authority. Accordingly, we do not propose to uphold the decision of the High Court because it seems to us that it is wrong in principle and cannot be justified by the terms of the relevant provision. A decision should be treated as given per incurium when it is given in ignorance of the terms of a statute, of a rule having the force of statute. So far as the order shows, no argument was addressed to the court on the question whether or not any direction could properly be made, compelling the municipal corporation to construct a stall at the pitching site or so and so. Editor of Salmon Jurisprudence explains the concept of subsilentio in these ways. A decision passes subsilentio in the technical sense that has come to be attached to that phase when the particular point of law involved in the decision is not perceived by the court or present to its mind. The court may consciously decide in favor of one party because of point A, which it considers and pronounces upon. It may be shown, however, that logically the court should not have decided in favor of the particular party unless it also decided point B in its favor. But point B was not argued or considered by the court. In such circumstances, although the point B was logically involved in the facts and although the case had a specific outcome, the decision is not an authority on point B and point B is said to pass sub silentio. Likewise, my lords, in the next case, my lords, which is at page 287, Synthetics and Chemicals Limited case, my lord, which is a cause célèbre on the point of per incurium and sub silentio. Here, SCC 1991, volume 4, SCC 139, my lords. I'd like to draw my lord's attention to para 39, my lords.
Paragraph?
39, my lords. It's at page 310, my lords.
Yes.
Please, no. But the problem has arisen due to conclusion in the case of synthetics and chemicals. The question was if the legislature could levy, my lords, that I'll skip, that is with regard to whether levy could be imposed on industrial alcohol or alcohol fit for consumption, that aspect. Para 40, my lords, directly. Incuria literally means carelessness. In practice, per incurium appears to mean per ignorantium. English courts have developed this principle in relaxation of the rule of stare decisis. The quotable in law is avoided and ignored if it is rendered in ignorantium of a statute or other binding authority. Same has been accepted and approved and adopted by this court while interpreting Article 141 of the Constitution, which embodies the doctrine of precedents as a matter of law. Jayashree Sahu versus Raj Diwan Dubey, this court, while pointing out the procedure to be followed while conflicting decisions are placed before a bench, extracted a passage from Aylesbury's Laws of England, incorporating one of the exceptions when the decision of an appellate authority is not binding. Does this principle extend and apply to a conclusion of law which was neither raised nor preceded by any consideration? In other words, can such conclusions be considered as declaration of law? Here again, the English courts and jurists have carved out an exception to the rule of precedent. It has been explained as rule of sub silentio. A decision which passes sub silentio in the technical sense that has come to be decision is not perceived by the court or present to its mind. In Lancaster Motor Company, the court did not feel bound by earlier decision as it was rendered without any argument, without reference to the crucial words of the rule and without any citation of the, it was approved by this court in Municipal Corporation of Delhi, Gurgaon Court. The bench held that precedents substantially shown without argument are of no moment. The courts thus have taken recourse to this principle for relieving from injustice perpetrated by unjust precedents. A decision which is not expressed and is not founded on reasons, nor it proceeds on consideration of issue, cannot be deemed to be a law declared to have effect, to have a binding effect as is contemplated under Article 141. Uniformity and consistency are core of judicial discipline, but that which escapes in the judgment without any occasion is not a ratio decidendi. In B. Shamrao versus Union Territory of Pondicherry, it was observed. It is tried to say that a decision is binding not because of its conclusion, but in regard to its ratio and principles laid down therein. Any declaration or conclusion arrived without application of mind or preceded without any reason cannot be deemed to be declaration of law or authority of general nature binding as a precedent. So my humble submission is, my lords, these two judgments which the petitioners place reliance upon is contrary to the judgment laid down by the Honorable Supreme Court in Khudiram Das, and also contrary to the judgment of Pesala Nokaraju's case, which I have placed before my lords. Along with my
just 1 minute. So you are saying Amina Begum and
Jashila Shaji.
which is the other one you said?
Jasila Shaji. That's the latest pronouncement by the Honorable Apex Court, my lords, which my learned friend has shared a copy with me.
Just give that citation.
It is Jasila Shaji versus Union of India, Criminal Appeal number 3083 of 2024. The judgment was rendered on 12th September 2024.
My lords, the advocate on record has a copy of it there. Could pass it to my lords.
Now, these two you are saying are against the law laid down by the larger bench in Khudiram
Bose, and also three-judge bench judgment in Nukkala Pesaraju, which is at annexure R9 of my statement of objections.
Which is that? You just tell us the citation.
The Pesala Nokaraju is criminal appeal number SLP criminal number 9492 of 2023. My lords, it is annexure R9 in my statement of objections, my lords. At page 59 of my statement of objections.
You're saying these two, Amina Begum and the other one is in direct contradiction with these two.
Please, the ratio laid down in these two cases. One is a larger bench. Pesala Nokaraju is the three-judge bench, where his lordships, Justice D.Y. Chandrachud, Justice Parthivala and Manoj Mishra were part of the bench, my lords. And please.
Meanwhile, you make a small chart.
Please, my lords, I will. I beg for my lords' forgiveness.
Regarding this submission, that which paragraphs in which of the judgment is contrary to the larger bench judgment? What is the contradiction that you just make a chart?
Please, I will.
Yes.
Please, but lastly, my lords, the Hyder Consulting is also on the issue of per incurium. The relevant passages would be 46 to 47, my lords. I will not trouble my lords reading that. I'm sure my learned friend is already very impatient.
Para 46 to
46 and 47, my lords. Para 47 may be relevant, my lord. Page 337.
Yes.
Why I cite this particular case is, my lords. Para 46 describes what per incurium is, as it's been done in the earlier two cases which I've read from, my lords. Para 7, the conclusion. It is important, my lords.
Para 40,
7 on page 337.
just read.
Please, my lords. Therefore, my lords, para 46 is about the principle of per incurium. And for para 47, therefore, I am of the considered view that a prior decision of the court on identical facts and law binds the court on the same points of law in a later case. In exceptional circumstances where, owing to obvious inadvertence or oversight, a judgment fails to notice a plain statutory provision or obligatory authority running counter to the reasoning and result reached, the principle of per incurium may apply. So my humble submission is here, my lords. Vesala Nokaraju being an earlier judgment, Honorable Apex Court had to look into this judgment, distinguish it, and then they would have to say why they disagree with it, or they would have had to refer it to a larger bench. None of these two, none of that is done in both the judgments. Both in Amina Begum being a verdict of a bench of a lesser strength, division bench, and Jasila Shaji is a bench, which is a later verdict, where the court of equal strength, coordinate bench, was duty bound to look into the ratio laid down by an earlier bench. It had to either distinguish or refer to a larger bench. Neither of that has been done in that particular judgment. So hence, my lords, that the subsequent judgment suffers from the vice of being per incurium. And once it is per incurium, as my lords are aware, my lords, under Article 141, it does not become a binding precedent. And hence, this honorable court is not bound to follow, because there is no ratio or the principle or any proposition of law that flows from a per incurium judgment.
Yes.
Please, my lords.
Yes, Sandesh.
Much obliged. I'm grateful to my lords for your indulgence, my lords. Much obliged.
But
My lords, I beg for lords' forgiveness. I beg for
volume number 1, sir. Volume number 1.
I beg for my lords' forgiveness. Please, please.
226.
That was supposed to be my first case that I had to argue or read from, but my lords, I kept it for the last. My page number 226, my lords. This is a case where under the Gundas Act.
Mallikarjun, namnen bidalla.
I'm grateful to my learned friend Mallikarjun Basreddy ji, my lords.
Page 22.
Page 226.
Yes. Yes.
In this case too, the detention was passed under the Gundas Act, my lords, detention order. It was challenged on the same grounds, my lord. Page 239, my lords, onwards is the discussion of the Honorable Court, my lords.
Yes.
Please see the head, subheading C, page 239, my lords. May I read from there, my lords?
Yes.
The first submission of the petitioner's counsel that the detainee does not know reading or writing in Kannada and English cannot be accepted. Reasons for this are not far from the far to seek. His counsel on 35/2024 has filed voluminous paper book running into 935 pages in support of his case. The TC specifically states that the petitioner had studied Tamil and Kannada. My lords, I will take my lords to the next page, my lords, the conclusion on this part.
Yes.
In any event, it was open for the detainee to seek Tamil version of all the documents and order of detention, which he did not for reasons best known to him. So basically what the Honorable Court had come to a conclusion is, some document was not made available, they could have asked for it. He did not. So therefore, the decision in Povan Ammal versus State of Tamil Nadu versus and Jayama versus Commissioner of Police does not come to his aid, is what the court comes to, what court concludes. Then the Honorable Court looks into another aspect of the matter. The second submission that the detainee was not furnished with legible copies of the document and therefore is not in a position to fully comprehend the circumstances that led to making of the impugned orders again is unsustainable. There is no reason to doubt that the version of the respondent authorities that detinue was supplied with legible copies of all the documents. In fact, the subject paper book filed by the petitioner contains copies of the documents that are plainly legible. Despite turning the pages, learned counsel appearing for the petitioner not in position to demonstrate which was relevant. Added, such a grievance was not raised before the advisory board when the detinue admittedly participated in the proceedings. My lords may kindly mark that portion. Because in the first instance, when you had the opportunity to go before an independent arbiter and to bring it to their notice that this is the lapse in the state's service of detention order, he could have brought it to the board's notice. He refuses to, because my humble submission, my lord, to make a lawyerly argument, one may need scholarship. But to read what is there in a printed format, he just needs to know. He doesn't even have to be literate. If a paper is not legible, if a paper, nothing appears from the paper, he could have said so to the board. He has failed to. Assuming these documents are illegible, what prevented him from seeking legible copies at the hands of the respondent is also not forthcoming. Therefore, this contention appears to have been taken only as far as an afterthought and as a ritualistic ground, sans any substantiation. In view of that, no milk can be drawn from the observations of the coordinate bench in Jayama's case. Next, my lord. The next submission of the petitioner that the respondents failed to furnish to the detinue copies of the bail order secured by the detinue, and that has prejudiced his case in structuring the defense at the stage of making detention order, again does not merit acceptance. The detention order dated 4/4/2024 makes a reference to the several bail orders, giving full particulars of the case, such as courts which granted the bail, the dates of bail orders, and the cases in which they were made. The detinue has not, my lords may kindly see, the detinue has not and could not dispute these orders inasmuch as it is he who has secured them. Learned SPP is more than justified in vehement submission that all these bail orders are only referred to in the detention order as a part of chronology, if you want. They are not made a basis on which the detention order is founded. My lords may kindly see that, my lords. Added, despite repetitive submissions, the learned counsel appearing for the petitioner could not demonstrate his assertion as to how non-fulfillment of copies of bail orders has prejudiced the interest of the detinue. This is very important. Where unless prejudice can be clearly demonstrated, the question of indulgence of court, the honorable court, in this regard, with regard to such a pleading or submission, will not arise. The requirement of furnishing the foundational material of the detention order arises under the principles of natural justice. In the absence of demonstrable prejudice, the arguable breach of these principles does not provide a justifiable ground. Vide S.L. Kapoor versus Jagmohan, AR 1981, SC 136. My lord, that is the same that has been laid down in the other judgment which I brought to my lord's notice in the Ummu Sulima's case and Radhakrishna case after that. What is it? In Abdul Hakim's case, my lord, which is of a larger bench. Please. The reliance of petitioner's counsel on Apex Court decision in Rishikesh, Tanaji, does not come to his aid of the detention. And the authorities are wrong in the impression that the bail applications therein were still pending. They were already. My lord, this with regard to application of mine, as they have not raised that ground, I will not touch that aspect at all, my lords. And E, my lord, on page 243. E,
Yes.
subheading E. The next submission of the petitioner's counsel that the detinue has secured bails in all the pending criminal cases, despite subject to the stringent conditions, therefore, the detention orders could not have been made, is liable to be rejected for more than one reason. Firstly, as many as 45 criminal cases are pending against the detinue, he is acquitted in a murder case, giving the benefit of doubt is also true. It is not the case of petitioner that it was a honorable acquittal. My lords have introduced, the honorable court has introduced a new standard here. A honorable acquittal is a requirement for him to get a benefit of doubt. There is one case of kidnapping, abduction in crime number 29 of 2011, filed by none other than his wife, V. Bhanupriya, and the detinue has been acquitted. Here again, it is not a case of honorable acquittal. There are 2 attempt to murder cases, 1 robbery, 32 theft cases, 1 case of theft of public servant, and 4 cases of hurt. All they are spread over between 2008 and 2024 and different police stations. Full particulars are given in the statement of objection. It is also true that there were other cases in which he has been acquitted. None of them is shown to be a honorable acquittal. Like in the case before my lords, where all the acquittals are obtained because the witnesses have turned hostile. And which is also one of the reasons why we had to preventively detain him, because he was tampering with witnesses and evidence. Next, if it is the primary duty of the state as a guardian to protect lives and liberties of the subjects, this duty has become onerous nowadays, cannot be disputed. Crime rate is shooting up as the official statistics furnished by the National Crime Records Bureau, Bangalore, show. Women and children and aged and ailing have become the vulnerable sections at the hands of hooligans. The fear of law is diminishing. Sensible sections of society live in anxiety and insecurity. Higher levels of vigilance by the administration has become inevitable. As of necessity, a larger leverage has to be conceded to it for ensuring peace and tranquility in the society. Measures like preventive detentions are aimed at this. The criminal antecedents of detenue galore on record, and they lend credence to the contention of learned SPP, that is, detention is inevitably ordered after exploring all alternatives. The authorities who have field knowledge from the opinion as to whether detention of the kind is warranted, keeping in view a host of factors. The detention order was examined by the state government. Even the advisory board, comprising of 3 serving judges of this court, having looked into the matter, has chosen not to recommend for the revocation of the detention order. Essentially, matters like this belong to the domain of statutory authorities, and courts cannot run a race of opinions with the executive in due deference to the doctrine of separation of powers, which is recognized as a basic feature of the Constitution. Vide Keshavananda Bharati versus State of Kerala, year 1973, 1464. So beautifully put, my lords. I will that is my best argument. In fact, this paragraph is the best argument that I've made so far, my lords. G. The last contention of the petitioner's counsel that in all the pending matters, the detainee has been admitted to bail conditions, and therefore the detention order is not inexplicable, appears to be too far-fetched an argument. As already mentioned above, the criminal antecedents of the detenue abound on record. The number of criminal cases, the nature of criminality, the kinds of victims chosen by the detenue, all would leave no reasonable mind unbaffled. And admittedly, he is a rowdy cheater. None other than his first was kidnapped, abducted by him. He is facing a plethora of criminal cases. Is not in dispute. Due to mounting arrears, the investigation, trial, disposal of criminal cases would take years, if not decades. Such has become the administration of criminal justice. Less said is better. Ordinarily, for offences which prescribed punishment is not death, nor life in prison, offend to secure bail by raising slogan, bail is a rule and jail is an exception. Wide State of Rajasthan versus Balchand alias Baliye in year 1997, year 2447. Social conditions have undergone catastrophic change and people are living in different times. The principles and maxims of law are not immutable. They have elements of relativity. Their relevance is time and circumstance bound. Therefore, the same cannot be invoked mindlessly for granting reprieve, disregarding its consequence on the larger interests of the society, of the community. Added to the above, the consideration for grant of bail are much different from those for making orders of preventive detention. Although in both cases, the constitutional guarantees figure as a dominant factor in favor of the citizen, but no guarantee is absolute. In Apex Court, Vijay Narayan Singh versus State of Bihar, when a person is enlarged on bail by a competent trial criminal court, great caution should be exercised in scrutinizing the validity of an order of preventive detention, which is based on the very same charge, which is to be tried by the criminal court. These observations also lend support to the view that the court has to exercise some restraint while undertaking the scrutiny of preventive detention orders made under the 1985 Act. If it were to be punitive order, different considerations would have weighed with the court. The immunity clause enacted in Section 6, capital A, which must certain arguable irregularities in the order of detention, also supports the stand in the absence of any challenge to the same. In a system governed by rule of law, there cannot be an island of immunity from judicial scrutiny is also true. Detention orders of the kind put the citizen to prejudice cannot be much disputed. However, they are an exceptional price which a citizen pays for being a member of a civilized society, but conditions applicable to him and not applicable to the rest. The avalanche of criminal cases which are still pending, many after investigation and arrest in pre-charge stage, repel the contention that the detenue is absolutely innocuous. After all, it is not a case of indefinite detention. The Act itself prescribes a maximum period of 1 year, as is specified in the impugned order. Section 14 provides for revocation or modification of the detention order by the state government. The detainee can tap this provision. He can also seek temporary release from the detention or for the curtailment of the period of detention as provided under Section 15 of the grounds do exist therefore. In the above circumstances, this petition being devoid of merits is liable to be and accordingly dismissed. Costs have been made easy. Humble submission, my lords. I could not have made a better argument than the passages that I've read out from this last judgment, my lords. One, my lords. Second, my lords, factually, it is incorrect to say that there is a snapping of liveling because the detainee was very much in Gulbarga, and on occasions he's been asked to come to the police station and execute bonds. So his presence in the town and his potential to cause disturbance is continued till 2024, 1.5 months before the order was passed. Therefore, my lords, my humble submission is, in all counts, my lords, the petition fails and hence deserves to be dismissed. I again place on, I would like to express my gratitude again to my lords for the indulgence shown to the state. Much obliged.
We'll continue at 2:30.
Please, let's.
One submission, there is a being spoken, my lordship. There is an error in judgment, delay, our appeal is there, I mean, non-appeal delay interest period categories.
Kodi. That's-
Serial number 5. Reopening day.
2:30, you make a mention at 2:30.
My lord, serial number 51, my lords. Kindly be taken on after vacation, lordship, one date to be given, lordship.
You make a mention at 2:30.
Please, lord.
ಮಧ್ಯಾಹ್ನ 2:30. ಬರೀ ಸರ್ ನೀವು ಇರ್ಬೇಕು. ನಿಮ್ದೇನ ಯೂನಿಯನ್ ಬಗ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ ನಿಮ್ದು? ಅದೇ ಅಲ್ಲ ಜೂನಿಯಟಿ ಬಗ್ಗೆ ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ ಇರೋದ ಮೂರೇ ಎವಿಡೆನ್ಸ್ ಇರೋದು. ಓಕೆ.
ಫೋನ್ ಮಾಡ್ರಿ, ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ನನಗೆ ಕೇಳಿ ಹೇಳ್ಬೇಕು ಸರ್. ನಾ ಹೇಳ್ಬೇಕು ಹೇಳಿ, ನಾ ಹೇಳಿದ್ರೆ.
ಸರ್ ಮುಗಿಸ್ತೇ ನೋಡಿ, ನಂದೀಶ್ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು, ಗ್ರೇಟ್ಫುಲ್ ಟು ಯು.
ವಿಜಯ್,
ಸರ್ ಇದು ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಇದೆ.
ಆಯ್ತಲ್ಲ, ಮುಗೀತಲ್ಲ ಇನ್ನು?
ಮುಗೀತು.
ಇನ್ನು ಏನು ಬಿಟ್ಟಿಲ್ಲ ಅಲ್ಲ?
ಏನಿಲ್ಲ. No.
Okay.
No, out of that 21 judgments, I've read only from around 9 of them. That's all. I have ended.
That's all.
That's all.
Okay. Chal, I'll see you.